your argument to Mr. Rabb, if you want to restate your objection, and then I'll go to Ms. Armpriester.
Absolutely, Your Honor. It's not so much of an objection.
Before you start, let me ask you, do you want Trooper Hernandez to be in the courtroom for this?
I do, Your Honor. Trooper Hernandez was previously informed to stay away from this matter. If the court rules in favor of the state, I would like Trooper Hernandez to understand why that is and the limits that the court places on that event.
Your Honor, that can be explained to him at a later time. My cross was based off of what was on direct. The trooper did go into that. At this point, I believe it could confuse his memory. I would ask that he, and all witnesses are sequestered, so I would ask that he be excused for this hearing.
All right, I'm going to go ahead and have Trooper Hernandez step out in the hall, since this is technically a sidebar argument. Thank you, Trooper. We'll call you back in when we're ready. All right. Go ahead, Mr. Rabb.
Yes, Your Honor. As the court's aware, there was a pretrial motion precluding the state from mentioning any marijuana that was obtained from the defendant by Florida Highway Patrol as part of their investigation. The state has not asked any questions about that. The state simply implied or asked during Trooper Hernandez's direct examination whether implied consent was read. Ms. Armpriester on cross asked whether or not, regardless of he gave a breath or not, the defendant would be released. Trooper Hernandez stated no. Ms. Armpriester is implying, and I imagine will argue in argument, that the reason Mr. Smith did not provide that breath sample is because he wasn't going to go anywhere. The reality of this is that there were other criminal activity as part of this investigation that would have held the defendant there, and subsequent to that, even if Mr. Smith would have provided a breath, and that breath would have come back with no alcohol in the system, the Florida Highway Patrol is able to request a urine sample and a DRE analysis or a DRE evaluation of the defendant to determine whether or not he was impaired.
Ms. Armpriester.
Your Honor, the state specifically asked on their direct twice, I believe, based on observations at mile marker 89 and then based on FSEs. Based on mile marker 89 and the FSEs, my client was under arrest and Trooper Hernandez was not going to unarrest him. That had nothing to do with any alleged marijuana. I don't even know.
That was not the question, Your Honor.
Yeah, I did not interrupt you. And he did not, and I don't even believe my client's in charge with marijuana. Either way, the way the information reads and the way that it's always read prior to the motion in limine was that he was under the influence of alcohol. My intent in asking that question, because the state brought it up on their direct, and the state said it in opening, and opening is not argument, it is what the evidence is going to show. And the state argued not only consciousness of guilt, which yes, they are allowed to argue, but if they're allowed to argue it, I'm allowed to counter argue it. And my argument had nothing to do with marijuana. It's very much a common occurrence that when an officer sees someone with whatever driving pattern we have, on top of interactions, on top of FSCs, my client was arrested for DUI. I was not opening the door to the marijuana in any way. I was following up with what the state promised the jury in opening, what they went into on direct. My only intent was that even if he blew, not even going into what the result would be, that to clear up what was said on direct, that it wasn't going to change his status as arrested for DUI.
Ms. Armpriester, you would agree, though, that the reason that it wouldn't change is because he had probable cause to arrest him for being under the influence. Marijuana was found in the car. Had he blown double zeros, they would have still had probable cause to keep him under arrest because of the marijuana.
Your Honor, none of that's even in the report. In a mythical, fictitious world, yes, that could be true, but in this, with the information that we had, those are not the facts that we had, with or without the marijuana being in evidence or limited out.
So how does your question to the jury implies that it doesn't matter whether he blew or not?
No, my question to it's not even my question or argument to the jury. My question for the witness was, there was no way, because of your observations at mile 89 and on FSEs, that Mr. Smith was going to leave the jail, which he had testified on.
Regardless of whether or not he blew, I believe that was your question.
Your Honor, he stated earlier and answered through no objection that he was arrested and that wasn't going to change.
Your Honor, may I respond?
Go ahead.
Trooper Hernandez stated on the bench, just to make sure the facts are clear, that he advised the defendant that they were going to conduct field sobriety exercises. The purpose of that was to dispel Trooper Hernandez's fear, whether or not the defendant was under the influence of alcohol or a controlled substance.
But he said alcohol.
And he did say alcohol, and I will admit to that. Trooper Hernandez then testified that, and it's on the dash cam video, depending on how you perform on those exercises will depend on whether or not you're released. His mind was not made up. Trooper Hernandez was not placing him under arrest at that point. It was after the field sobriety exercises that he was placed under arrest. The court has already stated the reason of why, even regardless if he blew clean at the jail, he would continue to be detained based on evidence that is in the report. The marijuana is mentioned in the report, based on evidence that was found at the scene or given to Florida Highway Patrol at the scene.
Your Honor, the officer's knowledge of impairment was alcohol focused. The defense's intention was not to open that door. I don't think obviously it's never anyone's intention to open a door of a pretrial motion. I was following up with what the state argued and with what the state said they were going to show an opening, what they wanted to on direct. And it was my last question that I was following up with. Because of the officer's testimony that either way, he was under arrest. And it doesn't even matter for what. Either way, he was under arrest. And if the court is inclined to agree with the state, I don't believe opening the door wider to allow them to bring in the marijuana is even the proper sanction. Under 403B, still my asking that question does not outweigh the danger of unfair prejudice. It's in no way probative. Nothing came out about the marijuana. At this point, if the court does agree that the door was open and allows it to come in, it only stands to confuse the jury.
Your Honor, Ms. Arnpriester literally mentioned multiple times in her opening argument, when all you have is a hammer, everything looks like a nail, implying that both Trooper Hernandez and Sergeant Munez's decisions were already made up. This is clearly in reference that their decision was not made up. There were field sobriety exercises performed. There was an opportunity for the defendant to dispel their fears. Multiple times he did not. The reason he would have been detained at the jail is because there was other evidence of his impairment that he refused to provide. The reason this is not a narcotic DUI is because it never got to that point. Since the defendant did not provide a breath and there was an odor of alcohol, the implication is he is DUI for alcohol. However, because of Ms. Arnpriester's question, implying that Trooper Hernandez was going to keep him, and likely implying during closing that his mind was already made up, because when all you have is a hammer, everything looks like a nail, there is absolutely probative questioning that can be directed towards Trooper Hernandez as to why the defendant was going to remain detained, even if he provided a breath, and even if that breath came clean.
Your Honor, the state is trying to think for me, and that is not my argument. That is not where I was going with it. That was my last question. I even stated I was done before Mr. Rabb asked if we could approach. I have no further questions. I did not open the door. I did not intend to open the door. And if Your Honor agrees that I did, I don't believe allowing that evidence to come in is the proper cure.
All right. Well, Ms. Arnpriester, I do believe that you opened the door to allowing questioning regarding any other substance that the deputies may have suspected that he was under the influence of based on what they found at the scene. And based on that question, I think the state has the absolute right to go into those issues as to why, even if he had provided a breath sample, he would have been continued to be under arrest.
I think that's fine, I just don't think the actual marijuana coming in is the proper cure.
Well, I've ruled that you've opened the door, so it does allow them to bring that up.
Judge, for appellate purposes, may I please have a written order on what the specific question that opened the door was?
Well, it's on the record.
Okay.
And Your Honor, may we speak with our witness, since he was previously informed, to not mention the marijuana issue?
You may. We'll take a brief recess, and then we'll come back, and then we'll bring the jury back in.
Thank you.
Thank you. Court's in recess. For State of Florida v. Jarrett Berg Smith, case number 20 CT 777. All right, State, are you ready for redirect?
I am, Your Honor.
All right, are we ready to?
You had indicated that I may finish my cross before you start.
Well, Ms. Armpriester, that was off the record and that Mr. Rabb wasn't present.
Your Honor, I do believe Ms. Armpriest's last words were no further questions.
I do believe that too.
Well, the only issue now is that since the court has made a ruling, I said no further questions prior to that ruling is, since I opened the door to something, then it's only fair I continue, otherwise it will be outside the scope of your act.
Recross.
It wouldn't be outside of the scope of redirect because you've opened the door.
I understand, but what I'm saying is since the objection came, okay, I'm not gonna be allowed to finish now, that's fine, I don't wanna,
You'll have an opportunity to recross.
understood.
All right. Are you disputing whether or not you said no further questions?
I have no comment.
Well, I mean, I can call Court Smart and we can replay it.
I thought based after my last conversation, despite off the record, even after you said, I thought that too, that was what I've been preparing for during this recess, so.
Well, you did kind of catch me off guard there. So,
Ready to proceed? I'll ask during recess.
I'm sorry?
I will ask my questions during recess.
Okay. All right. Let's go ahead and bring the jury in. And let's bring in Trooper Hernandez. Yes, please. Come on up, Trooper Hernandez. Thank you. Thank you. You may be seated. All right, we have the jury back with us. All members are present and accounted for. When we last left, Ms. Armpriester was finished with cross. Mr. Rabb, any redirect?
Yes, Your Honor. Thank you.
All right.
Trooper, hello again. Trooper, I'm going to ask you some questions based on Ms. Armpriester's questions right now. So, Ms. Armpriester, just first and foremost, did you make your determination that there was not a crash between Mr. Love's truck and the defendant's vehicle based on Mr. Love's statement or based on your investigation?
My decision was based on my investigation.
And that had physical, or for that matter, lack of physical evidence?
That's correct.
Mr. Armpriester also mentioned that in some crashes, some vehicles have more damage than another.
Is there an objection?
Yes, relevance is already asked and answered, and not to what the subject of recross that we agree would be.
This is redirect, overruled.
If I may restate
You may.
Thank you. Ms. Armpriester mentioned that in some crashes, some vehicles have more damage than others. Do you remember that question?
Correct.
Do you
Yes.
remember your answer to that question?
Yes.
And what was that answer?
Correct. That's true.
If a vehicle is not involved in a crash, does it have any damage to it?
Objection meeting.
Overruled.
If a vehicle is not involved, there's no damage.
And did you observe damage to Mr. Love's vehicle?
I did not.
Now, let's hypothetically say that Mr. Love's truck and the defendant's vehicle was involved in a crash. Based on your training and experience, and based on the amount of damage that was done to the defendant's vehicle, regardless of the size of Mr. Love's truck, would you have expected to see some evidence of damage or an indication of a crash?
Yes.
And how much evidence did you find?
0.
And you stated that your investigation on scene at mile marker 89 with the two vehicles was about 40 minutes.
Yes.
So this was not a quick decision that you made.
No.
Ms. Armpriester also asked whether or not you guys talked about whether the defendant requested medical attention. I believe you stated that he asked whether he should call or whether you should call the ambulance. Were you aware that the defendant had previously turned down EMS services at mile marker 89?
I was.
And in addition to that, if you had no evidence that there was a crash at the scene, would you have requested EMS services?
No.
And again, just because the defendant's vehicle had damage on it, does that mean that it was in a crash, that right there and then?
No.
Ms. Armpriester mentioned the stimulus light that you used, and then wouldn't let you complete your answer. Can you tell us about that light?
Objection, Judge. Argument for counsel.
Sustained.
Trooper, can you tell us about the light on your stimulus?
Yes. I have it here. This light here, when I conduct these exercises, I place my index finger on top of the light. And essentially what it does is it illuminates my finger. So at no point does this affect anybody's eyes. It's just my finger would be red when it's on.
So would there have been any light shine? I'll let you place that back in your pocket, Trooper.
Like that.
Thank you. So would there have been any light shining into the defendant's eye?
No.
Ms. Armpriester, I believe, asked you whether swaying is common for someone who was just involved in an accident. Based on your training and experience, is swaying also common for someone who's impaired?
That's correct.
Ms. Armpriester also mentioned, or I guess stated, the defendant didn't fall down, and you said that that was right during
Yes.
the drag exercises.
Yes, he didn't fall.
Does someone have to fall down to be impaired?
No.
Okay. Now, falling down would be an indicator of impairment,
Correct.
correct? Is it necessary that someone falls down to determine that they're impaired?
No.
Ms. Armpriester also mentioned practice makes perfect. Did you see Ms. Armpriester do a walk and turn in her heels today in court?
Yes.
Did she look like she was having?
Overruled.
Did she look like she was having difficulty doing that?
No.
Judge, I'm not on that. Objection.
Overruled.
Trooper Hernandez, Ms. Armbruster also asked you whether or not you were informed if the defendant had ever completed field sobriety exercises before. Do you recall the defendant mentioning to you that he had done pen to eye previously?
I don't recall.
Again, on the one-legged stand, Ms. Armbruster said he didn't fall. For that particular exercise, does someone need to fall to be determined to be impaired?
No.
Better yet, Trooper, let me ask you this. Did any of the exercises that the defendant performed comply with the instructions that you gave him? And in its totality, were there deviations from the instructions you gave him? So for example, you mentioned on my original direct, his instructions for pen to eye was to follow the stimulus with his eyes and his eyes only. Did he do that?
No.
When he did the one-legged stand, did he stand with his legs straight?
No.
Did he look at his foot?
No.
Did he have his arms to his side?
No.
During the walk and turn, did he touch heel to toe on every step?
Not every step.
Did he do the turn the way you instructed him to do the turn?
He did not.
So did he follow those exercises to your instructions that you gave him?
No.
Is that also one of the purposes in determining whether or not someone is impaired in performing field sobriety exercises?
That's correct.
And I do just want to clarify one thing. Ms. Armbruster mentioned, I guess, an admission in your report, and then there's this other packet that, does Florida Highway Patrol have an additional report or packet that they fill out for DUI specifically?
Yes.
So that would be separate from your written report, correct?
That's correct.
Okay. And you filled both of those out?
Correct.
So when Ms. Armbruster mentioned a report, consciously, were you thinking of your written report or your DUI packet?
I was thinking about my packet.
Okay. Now, Ms. Armbruster also mentioned that when you read implied consent around 7:24 a.m., that was about 3.5 hours after the initial call. Is that right?
Yes, approximately.
And at that time, you still smelled a strong odor of alcohol on the defendant's breath.
I did.
So Ms. Armbruster then asked you in her last question whether or not you would have released the defendant if he would have provided a breath sample. In this case, if the defendant would have provided a breath sample and it would have come back completely clean, would you have released the defendant?
No.
Why?
I would have requested if it on a breath sample, it would show 0-0 if it would have come out clear. At that point, I would have requested a drug recognition expert.
And why would you have done that?
Marijuana was located on the subject.
And did the subject voluntarily give you marijuana at that time?
Yes, he handed it to me.
And did you observe an odor of marijuana on either the subject or his vehicle at that time?
In his vehicle.
And is it driving under the influence if you are driving under the influence of marijuana as well?
Yes.
Now, nevertheless, even though you smelled that odor, you did state that you still smelled a strong odor of alcohol coming from the defendant's breath, correct?
Correct.
No further questions, Your Honor.
All right, any recross?
Yes, Your Honor. Agreed, Your Honor.
All right.
Trooper, when you initially did your inspection of Mr. Love's truck, you would agree it was dark out, correct?
It was dark.
And you stated on direct and then Recross, and now Recross, I'm asking it again. You testified that you did not inspect Mr. Love's tires, but your sergeant did, correct?
I did a walk around, and that consists of looking at all the anything on the truck around that's visible, but I did not measure the threads and stuff like that.
So you did not fully inspect the tires to see if perhaps that is what caused the injuries to Mr. Smith's vehicle?
I didn't inspect the tires to that extent, no.
Okay. And earlier you stated that you've investigated roughly 200 crashes.
Approximately, yes.
And it's common that people initially do turn down EMS because of what you testified to earlier, adrenaline, excitement.
Objection, Your Honor. commonality of other cases is irrelevant in this case.
Overruled.
You can answer.
Oh, yes.
Okay. And you stated on Recross that you determined that my client's car and Mr. Love's car were not in an accident, that was your determination, correct?
From my crash investigation, yes.
But you also determined that something definitely happened to Mr. Smith's car, correct?
I'm sure, yes.
And it had to actually be towed from the scene, correct?
Because it was out of gas.
It was inoperable?
He had run out of gas. It was disabled, if I remember correctly.
Was his back window missing?
Yes.
Was his back bumper smashed in?
Yes.
To the best of your knowledge, was he pulled over on the side of the road because his car was inoperable?
Yes.
And you stated again on Recross, could you please pull out your pen, your stimulus?
Yes.
May I see it?
Yes.
And can you show me again how you would have, or to the jury, how you cover it with your, would you actually step down, please? Judge, for demonstrative purposes, may the witness step within a social distancing box of the jury and show what that would look like?
I have no objection, Your Honor.
All right, go ahead, Trooper.
I think right here is a safe distance. Please just show to the jury what that light illuminated would look like. Thank you. Has everyone seen that? You can sit down. Thank you. And officer, on all the field sobriety exercises that were done, you stated on Recross that there were some instructions Mr. Smith didn't follow.
Correct.
There's also some instructions that he did, correct?
Correct.
And when you're conducting field sobriety exercises, are you looking for 100% compliance?
Enough to dispel my suspicion of being impaired.
And is that enough to dispel subjective or objective?
I don't understand.
Are you basing that on your opinion, or is there a cutoff number?
It's based on my training and experience.
So what you may determine is not what another officer may determine, because you have different training and experience, correct?
Depends on the officer.
It depends on the officer. Now, in terms of your testimony today is that, I apologize, Your Honor, may I approach my table, please?
Yes.
Your testimony today is that you noticed an odor of marijuana in the vehicle, correct?
Correct.
And being that you're a trooper with FHP, you are familiar with also the substance hemp,
That's correct.
and they're from the same plant.
I'm not too, I don't look into it that much, but he wasn't charged for the marijuana.
I understand that,
Okay.
but you nonetheless found a substance that you testified on direct that you labeled marijuana, correct?
Correct.
And you state on direct that you smelled marijuana, correct?
Yes.
And you recall giving a report in this matter?
It's in my report. I believe so.
It's in your report that the car smelled like marijuana?
Oh, no, it's not.
And you're trained to give detailed and accurate reports?
Correct.
Is it fair to say that your testimony today is not what your sworn statement was on April 25th?
And that being?
You did not, on April 25th, you did not make mention of an odor of marijuana?
I don't recall.
Okay. And would it help you to refresh your recollection if you viewed your report?
I don't believe I put it on my report because I didn't charge the defendant for marijuana.
And you didn't charge him with the marijuana. You also didn't test the marijuana to see it field tested, correct?
I did not.
And you didn't even test to see it, and we're using the term marijuana, it could easily be a legal substance hemp.
Correct, but
But
the
you don't know if
defendant
you
told,
didn't test it.
yeah, the defendant told me it was marijuana.
And hemp is, the defendant told you it was marijuana?
Yes.
He also told you it was hemp and CBD, correct?
No.
Okay. But regardless, you did not charge him with marijuana and you did not test the marijuana.
I did not charge him for marijuana, no, or test.
And again, officer, in your training and experience, is it your testimony that you're not aware of the difference between CBD, hemp, and marijuana?
Between hemp and marijuana, they would have to be tested.
Are you aware that even legal amounts of CBD and hemp can have THC in them?
I'm not aware.
Would it surprise you to know that?
Not sure.
But your testimony today is that you didn't charge him with marijuana, you didn't test it to see if it was a legal substance or not.
Correct.
No further questions.
All right. Thank you, Ms. Armpriester. Anything else from Trooper Hernandez?
Just a couple questions, Your Honor.
All right, I'll allow it.
Thank you. Trooper, going back to your measuring of the tires, as you mentioned, that Sergeant Verbees was the one that measured the tires. As a law enforcement officer, Florida Highway Patrol Trooper, are you a lone wolf or do you work with other law enforcement officers in your investigations?
Typically on my investigations, I work by myself.
Okay, and in this case, did you work with another trooper?
Yes.
And did his determination or did his part in that investigation lead to your conclusion as well?
That's correct.
So you were aware of his findings to determine whether or not a crash occurred?
Yes.
Okay. And then you did mention that the defendant himself told you that what he handed you was marijuana?
That's correct.
Okay. Do you have any reason to doubt that?
No. I did ask the defendant if he had a medical marijuana card and he stated he did not.
Thank you, Trooper. No further questions, Your Honor.
All right, thank you. Ms. Armpriester, anything else from you?
Not.
All right. Is Trooper Hernandez excused?
No, Your Honor, we will retain him for rebuttal.
All right. Trooper Hernandez, you're still under subpoena. If you could step out into the hallway.
Okay.
Thank you. All right, State, you may call your next witness.
Your Honor, the state rests in its case in chief.
All right, thank you. Members of the jury, the state has rested its case in chief. I need to go over some things with the parties. I'm going to give you another comfort break here, and then we'll call you back in a few minutes, okay? So the court will be in recess for the jury.
All right,
Thank you. You may be seated. All right. Ms. Armpriester, do you need an opportunity to speak with Mr. Smith about his right to testify on his own behalf and his right to remain silent?
No, Your Honor, our understanding is that you would like to utilize his right to testify.
All right. Mr. Smith, will you stand and raise your right hand to be sworn by the clerk? Will you state your name for the record? Thank you, Mr. Smith. You can put your hand down. Mr. Smith, your attorney has indicated that you wish to exercise your right to testify. Is that correct?
Yes.
And she's had an opportunity to review with you your right to remain silent. Do you need an opportunity to speak with her about your rights before we proceed? Okay. All right. I'll give you a couple minutes.
Your Honor, before we get there, may the defense move to make their motion to judgment as well?
Yes, go ahead. Mr. Smith, you can have a seat
May I first go to you, Your Honor?
if you'd like.
Either. Your Honor, at this time, pursuant to Florida Rule of Criminal Procedure 3.380, the defense moves to make their motion of judgment of acquittal. Viewing the evidence in the light most favorable to the state, the defense is of the position that they have yet to establish a prima facie case for that of DUI. To prove the crime of driving under the influence, as the court is well aware, the state must prove the following two elements beyond a reasonable doubt: that my client drove or was in actual physical control of a vehicle, and that while driving or in actual physical control, he was under the influence of alcoholic beverages to the extent that his normal faculties were impaired. Judge, the normal faculties is defined by our legislature as the ability to include, but are not limited to, the ability to see, hear, walk, talk, judge distances, drive an automobile, make judgments, act in emergencies, and in general to normally perform the many mental and physical acts of our daily lives. And judge, impaired means diminished in some material respect. Your Honor, yesterday the state spent the whole day putting on evidence as to some sort of accident that may or may not have happened. Mr. Love was on the stand for quite some time. He did give some testimony. Your Honor, all he's able to say is that a silver Nissan was driving erratically, almost caused an accident. 1 minute it did cause an accident. He had to have hit him, the next it didn't. He states on his sworn statement and testimony to officers that he was confused. He was confused with me. I don't believe that is, in terms of the credibility in weighing the evidence, helps the state establish a prima facie case for DUI. There was no evidence from Mr. Love about my client's normal faculties. He did testify that the way my client was acting wasn't normal. With respect, Mr. Love doesn't know my client. His version of normal is very different than the normal for Mr. Smith. Judge, in terms of normal faculties, we saw on not only Sergeant Munez's video, but the video today, my client had the ability to walk, talk, make judgments, act in emergencies. The law doesn't say that they act the way you or I would act in an emergency. It doesn't say that they have to walk perfectly and talk perfectly. The video that we saw shows him well in check of his normal faculties, not choreographed exercises that the officer had him do. Your Honor, even despite the ruling that the defense opened the door, even with that testimony that came out, the officer never was going to charge him with marijuana. He did not test the marijuana. It appears we made a bigger deal of that than even Trooper Hernandez did. There was never, even from what I gathered from the testimony, a suspicion that he was under an influence of marijuana to the point that he could not drive. The officers in this case were hyper-focused on alcohol, and with or without the legal hemp, non-legal marijuana, the argument's the same, Judge. The state cannot meet their burden. At this point, even the lowest standard has not established that Mr. Smith was under the influence of alcohol to the extent that his normal faculties were impaired. And as such, I request that you grant our motion for judgment of acquittal, as Mr. Smith is not guilty.
All right, thank you, Ms. Armpriester. Mr. Rabb?
Yes, Your Honor, thank you. Your Honor, viewing the evidence in a light most favorable to the state, along with the defense admitting all evidence and all inferences therefrom, the state has clearly established that Mr. Smith was driving or in physical control of a vehicle at both mile marker 69 and at mile marker 89. In addition to that, the evidence that the state has provided through testimony and physical evidence via dash cam has established that the defendant had an odor of alcohol coming from his breath, had slurred speech, had bloodshot, watery eyes, gave multiple stories of what was going on, seemed confused and disoriented, that he did not know where he was, whether it was Naples or Pembroke Pines. He was on his way to Pembroke Pines, yet he is in a Naples, what is effectively a Naples address 10 miles outside of mile marker 101. Viewing all the evidence in a light most favorable to the state would request that the motion for judgment of acquittal be denied.
All right. Did you want to respond to that?
Yes, Your Honor. Even with Mr. Rabb's argument, it is not illegal or a DUI to be driving after an accident and to be getting to a safe place. He did pull over, there was some confusion. However, that does not mean he was under the influence of alcohol to a point that gives rise to a crime.
All right, thank you. All right, in the light most favorable to the state, I find that there's sufficient evidence for the jury to determine whether or not Mr. Smith was driving under the influence. So the motion for judgment of acquittal is denied.
Thank you, Judge.
Thank you. All right, any other motions we need to address?
I would just need some time to speak with Mr. Smith. I am looking at the clock, the defense does return to call two witnesses.
Who-
Not sure
do-
how the court likes to schedule the rest of the afternoon.
Do you know who you're going to call first?
No, I need to speak with Ms. Diaz.
All right, how much time do you need?
10 minutes?
Okay, I'm going to hold you to that 10 minutes, Ms. Armpriester. Your timing has been a little off this morning, so 10 minutes. That'll be 11:21.
Thank you, Judge.
Okay, thank you, Ms. Armpriester. We'll be in recess. All right, we're back on the record. State of Florida v. Jarrett Berg Smith, case number 20 CT 777. All parties are present, including Mr. Smith. Mr. Smith, I'll turn to you again. Did you have an opportunity to speak with Ms. Armpriester about your right to remain silent as well as your right to testify on your own behalf?
Yes.
And do you need any additional time to speak to her?
No.
And have you made a decision? Are you going to testify?
Yeah.
Okay. All right. Thank you. Anything else we need to address, Ms. Armpriester?
Your Honor, Mr. Rather,
You may. Do we need to turn this sound on? Oh. Anything else we need to address? All right. And so for time purposes, Ms. Armpriester, have you decided which witness you're going to call first?
I'd like to call this, I'd like to call my client first, Judge.
Okay. And how much time do you anticipate his testimony to take?
Your Honor, with using video, I believe it could take up to an hour. I'm not sure how long the cross would be. But I'd like to allow an hour for direct.
Okay. So, let's see, the jury got here at 8:45. I think we could probably go ahead and do direct and then let them take a lunch break then. I may, if they look like they're waning, take a break earlier. Is that acceptable,
Yes, Judge.
Ms. Armpriester?
Yes, that's
Okay, let's,
fine. Judge, we just might need before we bring in the jury just to set up the technology so that it's
okay,
done and ready to go.
go ahead.
Just, Your Honor, if I may inquire,
Yes.
out of curiosity, just to know the videos that are going to be played.
At this point, the ones of the FSCs.
Are the ones that are already in evidence?
Right. Yeah.
That are, so the redacted. Okay. Just making sure.
Madam Clerk, may I please have the videos of the students submitted? Both of them? Yes, please.
Ours is out there. My hope is that Google is not play it.
I think it's Windows. Both.
Yeah, it looked like media player.
I'm sorry.
Your Honor.
It looked like Windows media player.
Yes, Your Honor.
Okay, Your Honor, I just need to get this then connected to the TV, but it doesn't bring up the TV.
All right, do you want to go ahead and connect it to the TV now or?
Yeah.
Okay, all right. Can I go ahead and request the jury to be lined up? Okay.
Here's what for. Go ahead and bring the back ones line.
All right. The, we can go off the record. Okay, go ahead. Be off the record. I'm sorry, Ms. Armbruster, could you ask that again?
Your Honor, would you please re-ask Mr. Smith your questions on if he understands his rights and whether or not he would like to testify?
Yes. Mr. Smith, do you understand that you have the right to remain silent as well as the right to testify on your own behalf?
Yes, sir.
All right. And have you had sufficient time now to speak with Ms. Armbruster regarding those rights?
Yes.
And have you made a decision as to what you would like to do?
Yes, I'm hopeful.
All right. And what is your decision?
I'm gonna testify.
Okay. All right. And no one's forcing you to do that?
No, sir.
Okay. All right. Let's bring the jury in.
344, don't bring it. Your Honor, the jury.
All right. Thank you. All right, thank you. You may be seated. All right, we're back on the record for State of Florida v. Jarrett Berg Smith, case number 20 CT 777. All members of the jury are accounted for and present. Thank you for your patience. All right, defense, you may call your first witness.
Judge, you would call Mr. Smith.
Sir, if you raise your right hand, face your front this week.
Do you solemnly swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth?
Good morning, Jarrett. Can you please introduce yourself to the jury?
My name is Jared Smith.
And for the record, can you spell your first name?
It's JARETSMITH.
Great.
My last name.
Jarrett, Mr. Smith, how are you employed?
Well, I was formerly employed working with the warehouse and logistics, but since this incident, I haven't been able to really work because I drive for my company that I used to work for. So I'm seeking
And
employment right now still.
you're seeking employment?
Yeah.
And where do you reside?
Pembroke Pines.
And that's in what county?
That's in Broward County, Florida.
And what were you doing during the early morning hours of April 25th, 2020?
Was trying to commute towards, Sandbar Island side towards a timeshare that we kind of have, and I got struck by the truck in general.
And what were you going to do in Sanibel?
It was most likely a kind of fishing, go relax for the weekend, because I'm older, so I don't go out and have fun for my birthday and stuff. So we planned the weekend to go just, go and relax with my kid and stuff.
Was it your birthday?
Yeah, that night it was, but I wasn't doing anything, special or anything. We had plans for the Saturday and Sunday.
And when you say we, who
Me and my girlfriend.
And just for purposes of the record, please just let me finish my question and then answer, because if we talk over each other.
Okay, I'm sorry.
That's okay. It's a common issue. So what happened while you were on your way to the timeshare?
Well, I was driving and
Where were you driving?
I was driving on Alligator Alley,
Which direction?
heading west.
And where were you coming from?
I was coming from Weston. I had made a quick stop over there to say hi to somebody and then continue my way because that was on the route of where I was going.
What was your quick stop, and about what time of the day was that?
That was around 12:30ish. A good friend of mine,
AM or PM?
AM. So he gets off of work at 12 because he works a night shift doing restaurants. And so the only time for us to see each other was around that time. And I happened to say, hey, I'm heading that way. I'm going to pass you, let me stop by and say hi. So after I did that, I got back on the highway to keep going towards west.
And it was stated during the state's case that you had told the officer that you had consumed a beer. When did you consume that beer?
That beer was consumed probably around between 12 and 1-ish at work and in my warehouse. That's something that
AM or PM?
that was PM.
So around noontime?
Yeah, around noon time.
And had your shift ended?
Yeah, I had got released early that day.
And so you had a beer after your shift?
Yeah, the guys in the warehouse kind of like wanted to celebrate for me.
And what happened? Strike that. You briefly testified that while you were heading west, you were involved in a car accident. Can you tell the jury about that car accident?
Yeah, so I was driving, and basically this truck was riding next to me for a while, and I kind of sped up because I didn't feel comfortable with him always staying so close to me out there in the middle of nowhere. So I kind of dipped, like, you know, I kind of dipped off a little bit more than what he was going, and he kind of accelerated with it. And then after hearing his truck, because my windows were down, after hearing his truck like speed up, you can hear the engine like, and that's when my car like boom, it lifted up like towards the front end, and that's when I pretty much broke him hitting me and pulled over, and then he kept driving.
And what did you do after you pulled over?
I pulled over. I noticed he kept driving, so I continued to follow him and flag him down, flash my lights, all that to pull him over, because I guess he realized that he had hit me, or you know, I just don't know what his intention was in general. Keep going.
Prior to him driving off, were you able to obtain his information?
No.
And prior to him driving off, were you able to see if you knew this individual?
No.
Do you, now that you subsequently know who he is, do you know Mr. Love outside of this incident?
No.
At what point did you come back into contact with Mr. Love?
When I had originally pulled over, I had sped up. I did speed up just to get ahead of him because he wasn't stopping, and I had pulled over and I flagged him down, and that's when he pulled over, and then I recorded, you know, something, and then he got out, and that's when the altercation began.
When you say that you got out, what was your intention when you got out?
Oh, I got out of the vehicle because I wanted to record his license plate, the tractor's number, and
essentially get his information?
Yeah, just get my information because it's an accident right now, and I have to, you know, submit that to insurance and stuff.
What happened after you took your necessary?
I was following rules to an accident, you know?
Sure. What happened after you took your photographs?
He came out, he said, you know, what's going on? And, you know,
did you say anything back?
I told him, I said, like, you know, in profanity language, you just hit me. Like, what were you thinking? Like, were you falling asleep? What happened? And he said, I didn't hit you. And then he continued talking, and he said, you know, I'll be right back. I'm gonna go get my phone. And then
Now, let me stop you. When he told you that he would be right back, he was going to get his phone, what was your understanding of what he was doing?
I didn't feel safe at that point, and that's when I got in my vehicle.
Was it your understanding that he was getting his phone to call 911?
I don't know at that point. He sounded very upset and aggressive to, like, whatever the situation is. I don't know why, if, you know, I just don't.
Were words exchanged?
There was some words exchanged with me, you know, telling him what had just happened, and he seemed confused and oblivious to, you know, what's going on. And he said, I'll be back, you know, I have to call my dispatch. So I, you know, didn't trust that too well. I'm out in the middle of nowhere, no lights, nothing, literally nobody. It's pitch dark.
Did you get a good look at his vehicle?
Just the back.
And how would you describe that vehicle?
Just for my safety, I stayed towards the back, closer to my car.
But even from the back of it, were you able to determine what type of vehicle it was?
Yeah.
And what was it?
It was a semi-truck with a tractor trailer on the back.
What kind of car do you drive?
Nissan Altima.
And about how tall would you say is your Nissan?
It's pretty short. It's not that high up.
When you
I would
were
say
outside your vehicle,
I'd say about 4 feet.
And when you were outside your vehicle, were you able to determine how much bigger the semi was than your car?
Oh, of course, yes.
And how much bigger?
It three or four car lengths bigger than my car.
And was the semi much taller than your car?
Yes.
Did you happen to notice how high the tires on the semi were?
No, but I have knowledge of seeing them before, and they're all pretty much the same.
And they're much taller than
Yeah,
your
they're
tires?
very tired. They're up to probably my window.
And at what point, Mr. Smith, did you come into contact with law enforcement?
Once it was, I believe his name is Muniz.
Mhm.
That was the first officer that seen me, and I was already out of the vehicle. I was checking on everything.
Where were you when you encountered Sergeant Muniz?
I was on the side of the road. I had pulled over because my car, I guess, it went disabled. Because where the impact was, it did hit my gas tank, so it drained all my gas out. Because I had a full tank before I left to make the drive to commute.
Was your car inoperable when you came into contact with Sergeant Muniz?
Yes.
And were you able to pull over to the side of the road?
Yeah, I did that previously, before. Like once I noticed the car starting to make weird noises more than what had already happened, that's when I fully pulled over to the right side.
Did you participate? Strike that. After you came in contact with Sergeant Muniz, did you come in contact with anyone else from law enforcement?
Yes, after Muniz came, he explained to me, hey, this isn't my route of road to take care of. I'm gonna contact an FHP, and he's gonna be on his way here.
And did that FHP officer come?
Yes.
And who was that?
Kevin Hernandez, Trooper Kevin Hernandez.
And what was your initial meeting with Trooper Hernandez like?
He was asking my side of the story and what had happened. He said, I heard his side of the story, and I want to hear yours. And we continued talking, and he kept telling me, hey man, your car is bad, it's done. He's like, I don't see any damage on this guy's vehicle. Whoever it was, they must have hit you and kept going. And that's what we kind of left out at. And then he asked me, other questions about, I guess for his safety, whatever his protocol is. And
Was he, as part of that, was he asking you basic preliminary information?
Yes.
And then at some point, did he ask you to participate in field sobriety exercises?
2 to 3 hours later.
And did you participate in the field sobriety exercises?
Of course, yes.
And Your Honor, permission to move the TV?
Yes, you may.
Judge, how do you like
You may.
permission for the witness to step down?
You may.
Mr. Smith, can you step down? So now, we see on the video, the officer was conducting what he called the eye test review. Do you recall that?
Before you answer that, Mr. Smith, Ms. Armbruster, could you tell us which video this is? Is this?
Yes, I'm so sorry. This is Trooper Hernandez's video. State previously entered it into evidence. I will get the exhibit number.
All right, State's Exhibit 3?
Yes.
All right, and can you tell us which, for the record, what hour, minute you're at?
I am at 4 minutes and 27 seconds.
Okay, thank you. You may proceed.
I'm gonna grab my mouse to make it more convenient. So Mr. Smith, I'm gonna replay the exercise. And before we do this, was there anything precluding your performance on these exercises?
like stopping me from.
Was there anything making it difficult for you to do
Yes.
these? What made it difficult for you to do them?
The impact from the accident.
Anything else?
Yeah, I had an injury in my leg before, or I've been like ran over by a tire on a truck.
And how long ago did that accident happen?
Probably like 3 years ago.
And I know this is a redacted video that we've previously seen and that we're gonna play now. Off the video, off camera, in any conversation with the deputy, did you inform them that you had injuries?
I wasn't thinking about that. I was just more confused of why didn't you find who hit my car?
During this though, were you feeling the effects of your most recent accident?
I couldn't tell because I was just, I felt like I had adrenaline running through me.
Okay, I'm gonna play the video at 4 minutes and 27 seconds. Now, it's difficult to hear. What are you and the officer discussing here?
You guys want personal questions about myself?
No, he's asking, so here the officer's asking you personal questions.
Yeah, he was asking me like some personal questions and stuff, and I guess continuing.
You hadn't
He was just-
started the
He
exercise.
was easing me through it, I guess, knowing that I was maybe not happy about doing it after an accident, but.
Can the jurors all see here? Now, what was happening during this time?
I believe I was explaining that I've been up since 6 in the morning, and that, I don't think I can, do this in general on top of being hit. And
Were you having any trouble standing up straight?
yeah, it's hard for me to like lean on one side to another side. 'Cause
But-
it's,
But that's your normal
yeah, that's my normal.
physicality.
Yeah, I gotta always keep like shifting myself.
Now, when you were doing the pen test with the officer, he testified earlier and obviously you've been present. Was that light on the tip of it affecting you in any way?
I mean, it is bright when it's that close to your face and not from a distance. So it kind of is like, a distraction from what you're doing.
Were you doing your best to stand still?
Oh, yes.
Were you doing your best?
I was
to
doing my
comply?
best to do everything he was asking.
And Judge, I'm now going to move the video. Judge, I'm going to cue it up to 12:23.
All right, thank you.
Actually, Judge, it's 7:02. I apologize.
Okay.
Now, what were you doing right there?
I was putting my cell phone on there because I was holding it in my hand. I was talking to something in those minutes.
Did you have any trouble walking to the deputy's hood of his car?
No, I was just trying to hurry up to put the phone there and get back.
And that's your normal walk?
Yeah.
And did you have any trouble turning around to get back to the deputy to begin the exercise?
That's the thing. I know I did from the impact, so this is just like aftermath of me trying my best to.
But my question is, when you were walking back to him, you didn't have any trouble, you weren't falling down, you were?
No, not at all.
Now, what just happened there, the conversation, what were you telling the deputy there?
I was telling him again, before we do this, remind you, I just got hit, so you're not gonna get 100% of me walking as if I wasn't hit.
And do you recall, it's difficult to hear on the video, do you recall what his response was?
He said, we already discussed this, we're here now, and this is what you have to do.
And was that your request for medical services?
I asked him because of his professional, I know that I might not be in the right state of mind after having an impact like that. And I trusted him to say, hey, your car's totaled, you look okay, but you might not be okay.
Did you not feel okay?
The next day, no at all.
But in this moment, when you were speaking with the trooper, were you thinking that you needed to be seen by a medical professional?
By that time, yeah, but I wanted to just complete what he was asking.
Now, before we actually watch your performance on the walk and turn, and for the benefit of the jury, since the audio is hard to hear, Your Honor, may I return to the podium?
Wait, are you done with the video?
Not quite yet. I just have a minor question. Before you did this in the subsequent exercise, did you feel your best?
No.
And did you tell law enforcement that you did not feel your best?
They asked me if I felt okay, but I was just trying to be a man about the whole situation and just say, yeah, I'm good. I don't have a scratch on me, at that moment.
And again, the audio is difficult to hear, but was the walk and turn explained to you?
Yes, this was explained.
And did you understand it?
Yes.
Did you understand it fully?
Not to the full extent. I understood the common ground of what he's telling me to do.
Do you recall what shoes you wore that day?
Yeah, flip-flops.
And did that affect your performance on the walk and turn?
It did, but he also told me I could kick them off, and I declined that too because we're out in the middle of
Did you have another pair of shoes to put on?
Oh, no.
So you would have had to do
I wasn't offered a pair of shoes either.
So you would have had to do them barefoot or in your flip-flops?
Or in my flip-flops.
And did you do your best to comply with the officer's directives?
Yes.
And prior to the one-leg stand, was the one-leg stand explained to you?
Yes, it was.
Did you understand it?
Yes.
Did you understand it fully?
Not too much. I just knew that he said you just lift the leg up and hold it until I tell you to put it down.
At this time, were you still wearing your flip-flops?
Yes.
Did those flip-flops affect your performance?
Yeah.
did you think you would have done better in them barefoot on the pavement?
Barefoot? No. Maybe in a tennis shoe.
Judge, if I may approach the TV.
You may.
Mr. Smith, you can step down, please. Why did you start ahead of the ahead of the officer's name again?
He was pretty much telling me, and then he said, hold on, I'll do it with you so you get an idea. He was showing me an example first before I started.
So you weren't trying to.
I was just trying to start it and get it over with, and he said, no, hold on, I'll show you, step by step.
It wasn't your intention to not follow directions.
Yeah, no, I wasn't doing that.
And what just happened there?
I guess he told me, no, go back to it again, because we're talking to each other. I'm looking at him while I'm talking and I'm focusing. So he's just teaching me right now what he needs me to do.
So you fought, correct?
Yeah, so I thought.
On the line. You can take it without lifting it up and down. Alright? Back down the line. Okay, you see how I use my weapon now? Alright.
Mr. Smith, was it as hard for you to hear Trooper Hernandez as it is for us to hear him on the video?
Yeah, as you can see, I'm leaning in trying to hear him because there's just so much traffic with those trucks going by.
And you were doing your best to listen?
Yeah, I'm doing my best to listen.
Alright? That one? You have to watch it before you do so, okay? You ever take a church before? When I think you begin, you take 90% down the line. Okay? Okay, 1, 2, down the line, okay? Again, you look forward, comfortable, on the line, take 6, small steps, turn around. And turn 90% back on the line. So, go like this. Go like this. Back, 5, 7, 8, 9, and then 6 small steps. Turn around, back down the line. Okay? Go along, you want to see it all the time. Keep your arms at your side and turn your steps out loud. Once you begin, you don't come to where you're supposed to do. You continue first, 2, 3.
Now, your initial 9 steps, did you do your best to complete heel to toe each time?
Yeah.
And did you stay on the line the whole entire 9 steps?
I even turned, pivot on the line.
You can return to your seat, please. I'm here for TV.
Your Honor, May we approach?
For what purpose?
Pertaining to evidence not disclosed.
You may approach. The objection is overruled.
Mr. Smith, whose car were you driving that night?
It's my car, but my girlfriend owns it.
And you heard on direct earlier through Trooper Hernandez that a bag of suspect CBD hemp was found.
Correct.
And was that bag yours?
At that point, it's my girl's car, so she's telling me that she left something in there, and I wasn't sure. So he asked me for anything, and I just looked, and I kind of just gave it to him.
Was that bag of green leafy substance yours?
No.
Was implied consent read to you?
What is?
When the officer asked you for a breath sample, what did he read you implied consent?
He didn't ask me for any of that until later on.
But at some point, was it read to you?
Yeah.
And
yes.
Prior to having been read implied consent, were you already informed? Strike that. Where were you when implied consent was read to you?
I believe I was in his car when he said something to me about it. Because he initially, after him talking to me and stuff, he just told me to go in his car and just wait until he finished doing what he was doing. And I sat there for a while. And he came back and told me what he was doing after that.
When you say much later, can you quantify that for the jury? The initial call came in, it's been established just around 4 a.m. What time do you recall implied consent being read to you?
I'd say about an hour and a half later. Hour later.
Would it surprise you that implied consent was read at approximately 7:23 a.m.?
Yeah, I guess it was that late.
Based on the accident you were involved in, looking back, do you have a clear memory of April 25th, 2020?
Yes.
No further questions.
All right, thank you, Ms. Armpriester. State, and you may. Could the parties approach? State, you may proceed.
Mr. Say. So you stated that it was your birthday, April 25th, correct?
Oh, yeah, it was my birthday, but it just happened to be me traveling on my birthday. I wasn't celebrating in my car or anything like that.
And weren't you hanging out with your friends that night of the 24th?
Objection to the statement of testimony.
Sustained. Reword your question.
Didn't you tell the officers that night that you were hanging out with friends that night of the 24th?
No, I stated I stopped by to say hi because the person wanted to say hi to me for my birthday. We don't see each other much.
And didn't you tell the officers that night that you and your friends were making donuts in a golf cart?
No.
Objection.
Overruled.
And where's your friend's house that you stopped at that night? Where is it located?
Objection.
Overruled.
Where's the friend's house that you were at that night? Where is it
That's in
located?
Weston.
Is that in Pembroke
It's,
Pines?
no, Weston, Florida. It's off of I-75 and 595.
Didn't you tell Sergeant Munoz that night that you were coming from home?
Yeah, I was originally
Objection to the characterization of testimony officer.
Overruled. You may answer.
Didn't you tell Sergeant Munoz that day that you were coming from home?
Well, yeah, my original destination that I had left was home. And on my way towards, over this way, I had made a stop by somebody's house that lives off of 595.
And you mentioned with Ms. Armpriester that you were heading to Sanibel
Correct.
that night. But when you spoke to the officers that night, you did not say that. Is that correct?
Yeah, that's correct. Due to the fact that I had just had an accident, so my mind wasn't all there responding to it. The last thing I remember was that I was leaving in Weston.
In fact, the whole time you thought you were heading towards Pembroke Pines.
No, I was questioned after the impact, so I could have been lost in direction and all kinds of stuff that I know of, because I'm hearing and seeing it too, and that's the only thing that could have been.
And where do you live?
Where do I live? Pembroke Pines.
And is that where you lived on April 25th, 2020?
Yes.
And how did you end up on, I'm sorry, you mentioned that night that you had missed your exit to the officers. Which exit was that?
That was the exit that I was trying to get off to go to a rest stop or just something in general.
And,
I wanted to take a break before I got on the road again.
And you mentioned that you attempted a U-turn. Was that not near an exit?
No, I I never really said I was trying to do a U-turn. There's nowhere really to U-turn out there.
You mentioned to Mr.
After I got hit, I wanted to go back home to my girlfriend because plans were canceled. No more going over here. Just figure this issue out now.
You mentioned to Mr. Love and to the officers that night that you attempted to do a U-turn. Isn't that correct?
No, I never. I have no reason to tell the driver of the semi truck that I was trying to do a U-turn. I was questioning him why he hit my car.
And you heard Mr. Love testify that he saw your car in the middle of the road still. Isn't that correct?
I heard him say that, but that's not the truth.
So you're denying that your car was in the middle of the road?
Correct.
Are you also denying that you were trying to do a U-turn in the middle of the road there?
Correct.
And Ms. Armbruster went over with you when you were explaining how the crash occurred. Can you please go over that?
Could you repeat the question?
I would like to clarify how the crash occurred with the defendant. As he spoke to Ms. Armbruster, it was a little unclear.
Sustained.
With Ms. Armbruster, I believe you mentioned that front of your car hit something and that was unclear. Can you please elaborate, or sorry, clarify that?
Objection.
Did the defendant testified as to something with the front of the car and with the crash, and that was confusing?
Sustained.
So you mentioned you were hit, but you never reported that, did you?
I do have a video of when I had got out.
That's not the question. Did you ever report that night?
Report it?
To 911?
No, I reported it to the owner of the vehicle that owns the car. I told her so.
Did you call 911 that night?
I didn't get a chance to because Lovin said that he was going to do it. And then he threatened me, so that's why.
And did you call your girlfriend that night?
Correct, yes. I was on the phone with her pretty much the whole time.
And that night, you told the officers that you believe that you were hit in your car in Broward. Isn't that correct?
No.
So you're denying that you said that to the officers that night?
Yeah.
It's in the
Overruled.
video. Didn't you also tell law enforcement that night that you were following Mr. Love and Mr. Love took off and left the scene?
No. Oh, when he originally hit me, he kept going. So I guess that's leaving the scene. He never stopped.
Didn't you follow him after that?
Of course, yes. To, you know.
Didn't you say you were afraid of him?
I was afraid of him after he threatened me.
So you followed him?
I wasn't gonna
after
let
that?
somebody get away that hit my back of my car. I wanted to get their license plate and so forth.
You told all law enforcement that night that when they asked you how much time passed from the point of the accident to when they arrived, you said 15 minutes. Isn't that correct?
15, 20 minutes. Again, my perception of things have been shooken because of the impact itself.
And when did you realize that your car bumper was missing? At what point?
Sustained.
There was testimony about your back window being blown out and that there was glass in the back seat and in the front seat. Did you also have glass in your hair from that?
I had glass in my hair, glass in the trunk.
But did you have any cuts on you from the glass?
Maybe in my head. I can't see on top of my head, but there was glass shards all over me. So
And you still?
There was glass all over me, pretty much.
And after that, you still didn't call 911 just to get medical services?
I mean, he was more worried about doing his investigation for whatever it was who hit me. So he just told me to relax and take it easy for right now. That I'd look good. I don't have a scratch on me or anything like that. And I trusted him.
But before law enforcement arrived, why didn't you give 911 a call to get medical services after?
Because it happened so fast, man.
Overruled.
Ms. Armpriester said in her opening that you were going to visit your girlfriend in Collier County.
Objection, Your Honor, outside the scope of direct, because the therein law by direct.
Sustained. Rephrase your question.
In direct examination with Ms. Armpriester, you stated that you're going to Sanibel with your girlfriend, and that's where you were heading, correct?
Correct.
But didn't you say that night that you had to work at 6 a.m. that morning?
Objection.
It's in the video.
Overruled.
I believe I said I wake up every morning to work at 6 every day, and that was kind of reason why I've been up 24 hours now at this point to the next day, and then he asked me to conduct that.
So are you denying that you told law enforcement that you had to work at 6 a.m.?
I told him that I work at 6 a.m. In general. That's my working hours, that I wake up every day at 6 a.m. That's the only reason why I would say that, 6 a.m.
Do you have an objection?
Judge, I object to explain to the jury my client's testimony was that he had worked at 6 a.m. the day prior, and it was not a trial later. His testimony was not that he had to get up after 6 a.m., that he was up the day prior.
And that's what he just testified to, so overruled.
And to clarify, you also said that you had to be at work in an hour to the officers that night.
I mean, at that point, at what time did I say that?
In the video when you were speaking to one of the officers.
I don't recall that. I said maybe I'm gonna have to be up in an hour I should be up in an hour from now to go to work, but I know it's Saturday and there is no work on Saturday, so. Plus I got let off at 12 o'clock during the day.
And I didn't hear Ms. Armpriester ever say that you went to see a medical professional after all this. Isn't that true?
Overruled.
You may answer the question. Did you ever see a medical professional after all this happened?
Of course, yes.
And when was that?
The next day.
And Ms. Armpriester was asking you if you could hear the trooper all right during the field sobriety exercises. But weren't you standing right next to the trooper when he told you the instructions?
I mean, if you stand out there on a highway and you try to listen to somebody, even if they're next to you, it's kind of tough. So I was just getting his direct order, what he was
But were you
telling.
just standing right next to him?
Of course I was standing next to him. He was standing next to me.
So you stated earlier that you were a driver for a warehouse logistics company, correct?
Correct.
So as you've already stated, you could lose your driver's license for a DUI.
Correct.
So your driver's license is important to you.
Objection.
Overruled.
So is your driver's license important to you?
Yes.
And it's important to your job at that time.
Correct.
But when given the opportunity to provide a breath sample, you chose to give up your driver's license rather than provide a breath.
No, that's not how it happened.
But can you answer the question?
No.
You stated that the crash occurred because the truck was riding you. But you told officers that you were in the merged lane. Isn't that correct?
I never told the officer I was in the merge lane.
So you're denying
No.
that you told the officers that night that you were in the merged lane?
We were riding next to each other and he merged.
Mr. Smith, if there's an objection, you need to stop talking.
Okay, I don't know. Thank you.
Outside the scope of direct and
Overruled.
So are you denying you told the officers that night that you were in the merged lane?
Overruled.
Please answer the question, Mr. Smith.
I'm confused. What do you mean by merge lane?
The merged lane that you were coming off of.
Coming off of where? I was driving straight. We were side to side of each other. Never came from a merge or anything.
So are you denying that you said that night then, that you were on the merged lane?
Yes.
So you keep saying that you don't remember things because of the impact, but you also just stated in direct examination that you had a clear memory of everything that happened that night. Isn't that true?
A year later, yeah, after a time of thinking.
So this far later, you remember everything, but that night you couldn't remember.
At the moment, no. I was not thinking properly at all. I had just suffered an accident, a tragic accident that I lost my car and so forth. And there was no question to who hit me or anything. It was directed towards something else.
And isn't it true that after you were arrested, you became angry with the trooper?
Overruled.
Please
You may
answer
answer.
the question.
I was frustrated because I felt he kind of made me feel like I was trusting him, and he turned it around to not be that.
Isn't it true that you blamed the trooper for your arrest that night?
Not doing his job fully. That's opinion of mine. I wasn't being directed to him in his, uniform, but I was just saying in general. He could have did better in figuring out what the issue was.
And yesterday you saw the video from Sergeant Munez's dash cam, correct?
Yes.
And in that video, you were overheard telling the deputy that Mr. Love called you a cracker, right?
Overruled.
Would you like me to repeat the question?
Excuse me?
In that video, you overheard that you were told the deputy that Mr. Love called you a cracker. Is that right?
Yes, he was calling me all kinds of names.
And you said back to the deputy that you don't treat people that way, right?
Yeah. So
However, you did treat the trooper after you arrested differently. Isn't that right?
this is 2 or 3 hour spans in between of realizing what's going on and knowing what's going on, and this is the outcome of it.
So after you told the deputy that you don't treat people that way, didn't you insult Trooper Hernandez several times that night?
Overruled.
Can you repeat the question again?
Sure. So after you told the deputy that you don't treat people that way, didn't you insult Trooper Hernandez several times that morning?
No, I never assaulted him.
So you're denying ever insulting Trooper Hernandez?
I mean, insulting as in, like, telling him something after he arrested me?
Yes.
After he arrested me, yes. But beforehand, no.
So
I was upset. Anybody would be upset after trying their hardest to do something. Hoping.
So you're not denying that you insulted the trooper several times after arresting you?
No, I wouldn't say several times. I might have said one thing or two things, but that's just out of being human, I guess, and dealing with a situation that the outcome wasn't what you expected.
So just to be clear, so you are admitting that you made insults to Trooper Hernandez after he
No, they weren't
arrested you?
insults. They weren't insults. We were just talking. He was talking back to me.
Thank you, sir. No further questions.
Any redirect?
Mr. Smith, you stated earlier that you called Bianca Diaz your girlfriend,
Correct.
and that you were on the phone with her for much of that
the-
incident.
Yeah, the whole time.
Why did you call her?
Why did I call her? Because it's her vehicle, and she's the only person I really talk to. I don't have too many friends or anything like that. And I thought I'd let her know what was going on in the middle of nowhere
Now, even though it's
for my safety, because
even though it's her vehicle and you drive it, is it a mutual shared couples vehicle that you two share?
No, it kind of is. When she wants to take the keys, she takes the keys and goes.
So you essentially share the vehicle.
Yeah, but I mostly have it.
And Ms. Santini asked you that you did not feel the need to call 911. Did you recall her asking you that?
Yeah.
And why did you not feel the need to call 911?
Because the driver of the semi, he said, "Hey, hold on, I'm gonna call somebody calm down.
And when Trooper Hernandez and you were talking, did you feel it appropriate to call 911 when law enforcement was already there?
Yeah, no, I knew that they were there.
And your anxiety, adrenaline, fear was brought up on cross. You only felt those things after you were threatened, correct?
Yes, and yeah, pretty much.
And did those emotions lead to your lack of perception of time?
Yeah.
And Miss Santini asked you about your insulting the trooper. Do you recall the trooper's testimony today?
No.
Do you recall telling the trooper that you were going to make him come to court?
I said I was taking this to court.
And
I did say that.
was it your intention to insult anybody by
No, it
exercising?
wasn't an assault.
Let me finish my question.
Sorry.
Was it your intention to insult anybody by exercising your right to trial?
No.
And when, after you were arrested, did your demeanor change because you were upset?
Yes.
Ordinarily, you're not an upset, angry individual?
No, I'm not at all. I don't act like that.
Is it fair to say that you had reached a limit at that point?
Yeah, I'd hit my peak of everything.
No further questions.
All right. Thank you, Mr. Smith. You may step down. Yes, will the parties please approach? Could you approach? All right. Members of the jury, at this time, we're going to take a lunch recess. I appreciate your patience this morning and your attention to all of the testimony given this morning. It is now 12:35. I would request that you be back from your lunch break and checked in with the bailiff by 1:45. We do have one food truck on campus today, as well as the cafe downstairs. Of course, you're free to leave the government campus if you'd like. Before letting you go, let me send you off with some reminders. Let me remind you that you're not allowed to communicate with anyone about this case. You cannot use electronic devices to research anything about this case. You cannot go to any location involved in this case. You may not have any contact with the defendant, witnesses, attorneys, or anyone else involved in this case. If you see one of the attorneys and he or she does not speak to you or even seem to pay attention to you, please understand that the attorney is not being discourteous, but is only avoiding the appearance of some improper contact with you. All of us are depending on you to follow these rules so that there will be a fair and lawful resolution to this case. So at that, we'll take a lunch recess and we'll see you back at 1:45.
All right, Secretary.
All right, thank you. You may be seated. All right, does the state have the, do you want to let Trooper Hernandez know that he can go to lunch if he's still out there?
Judge, before we get to even seeing the video, the defense would like to make argument as to even if the court rules that I did open the door, I believe the best evidence would be Trooper Hernandez to retake the stand. He can certainly come in and make a proffer to the court as to what those insults were that he didn't go into on correct.
Well, I'm going to deny that request at this time. I think the proper way to do this is to listen to the alleged insults made by Mr. Smith, and then to first determine if they are insults, and then we can go back and listen to what Mr. Hernandez or Mr. Smith said.
I'm trying to figure out how, just so I understand how I opened the door to it when the state previously.
There was no allegation that you opened the door, but that Mr. Smith may have opened the door by saying he never insulted Trooper Hernandez.
But what he clarified and what I brought up on Recross was that he was insulting after the arrest. He denied that. I also think the questions were not the clearest. That's no fault of anyone's other than misunderstanding the court. But I believe Mr. Smith did answer the question truthfully that after he was arrested, yes, he was angry, and yes, he may have made insults. So, however, I forget the exact verbiage, but in terms of saying that opened the door for this video to be played, when he did answer truthfully, I believe it was more or less of a confusing question.
Well, yes.
Sorry. The defendant did state after the arrest that he did maybe make one insult pertaining to that court, having him in court. There are several, many more insults made in the length of going to the jail. And so that is the impeachment part of showing that he was just saying, oh, there was maybe one when there's several.
Right. That's how I remember the testimony also. So let's go ahead and hear the portions of the video that you believe were other insults other than going to court.
I have it ready, or we can have it in the mic since it's just a car ride, so it's just going to be the audio.
I think it should be sufficient there.
Okay.
Also, Your Honor, for purposes of the record, if I could object to it's not a timely objection, Judge, but any knowledge of if my client insulted Trooper Hernandez would be speculation, unless Trooper Hernandez is on video saying, you insulted me.
Your objection's overruled. All right, go ahead.
Oh, you insulted Hey, dude, I swear to God, if I get fucking sick, I'll remember you, bro. I don't give a fuck. I don't give a fuck what car you're in, what the fuck you do, what life you live, where you live, any of that shit, dude. If I get fucking sick because of these fucking crackheads that live on the street, because of you, yeah, it is what it is, bro. Come to my fucking court date, dude. Come to my fucking court date. I'm gonna have a fucking lawyer because why? Yo, I got pulled over after I got fucking hit. I was in need of emergency. I wasn't calling because I was doing something wrong. He stopped me because of emergency. My car was disabled. It is what it is, bro. You got my chick out here driving around crazy. You got her with my daughter too. Hernandez, right? Yes, sir. All right, cool. Mr. fucking Hernandez, the dickhead of the year. Hey, look, there was no disrespect until you fucking put cuffs on me, bro. I don't give a fuck if you locked them and made me comfortable or not. There ain't nothing comfortable about this, dude. You're taking me somewhere I don't fucking know where I'm at. I don't know where I'm at, dude. Where the fuck am I? You're just taking me somewhere? Like, come on, bro. This is fucked up, dude. Fucked up, bro. You got me on the other side of fucking town and you're gonna lock me up? Because of suspicion? Your suspicion sucks, dude. I followed your fucking light. I did everything you asked. Yeah, I stepped a couple times sideways. Why? I'm in sandals. Oh, take your sandals off. Dude, I want to be in platform shoes. If I was in fucking my steel-toed boots, what? I'd stand fucking straight. Steel-toed boots stand straight. But you know that though, and you're gonna take advantage of that. You wanna look cool in front of your peoples. Do your thing, bro. I hope you fucking look cool, bro. You're so fucking cool, dude. So fucking cool, ruining somebody's fucking family, bro. Over nothing. I didn't fucking crash into nobody and hurt anybody. I didn't hurt nobody, bro. I didn't hurt nobody. Somebody fucking hit me. And that's what you do? Hey, again, karma is a motherfucker, and that's what it's gonna be, bro. So do what you gotta do, put me in a little intake, whatever. I'm not gonna fucking see a judge all fucking weekend. Fucking piece of shit, bro. Taking me away from my fucking daughter, bro. Alright. Mr. fucking faggot Hernandez, dog. Mr. Oh, I have to make a fucking quota. Oh, I have to look good. Oh, I pulled this guy over. You didn't pull shit over. Remember that. You fucking helped me out. That's what you were doing. And then you turned it into this. You were helping me out. And you turned this into this. It's fucked up, bro. Fucked up. There's so many people out here fucking raping kids, fucking doing drugs, selling drugs, and you fucking come at me for this shit? Oh, I can't walk in my sandals after I got hit by a fucking semi. Fuck out of here, dude. Piece of shit. Piece of fucking shit, bro. You hear this shit all day, I bet. But guess what? This one is gonna mean something to you. You're gonna remember this shit. You're gonna remember being a fucking asshole, locking somebody up on their fucking birthday when they got hit. I don't even fucking talk like this. But you got me in handcuffs so fucking far away from where the fuck I am. I don't know where the fuck I'm at. You brought me to somewhere I don't know, dude. Fucking asshole, dude. Asshole. You're gonna bring me around these sick ass fucking people, bro. Yo, I swear to God, if I get fucking sick in here, I'm gonna fucking come at you, bro. Trust me, dude. Hello, one male.
That's it, Your Honor.
All right.
Well, I mean, there's more, but we would stop it there.
So, Ms. Santini, I think the question was about insults. And I counted 8 insults, other than the one about coming to court. And I'll place those insults on the record. First, he called Trooper Hernandez the dickhead of the year. Second, he called him a piece of shit. Third, he called him Mr. Faggot Hernandez. Fourth, Mr. Corda. Fifth, piece of shit. Sixth, piece of fucking shit. 7, fucking asshole. And 8, fucking asshole. Ms. Armpriester, would you disagree with the court's assessment?
I would not agree that all of those are insults, but I would agree that they were said.
Is there a specific one of those 8 that wasn't an insult?
I just think saying things when you're upset that aren't directed. I counted 2 insults, Judge, that I would stipulate to as it, but that's my opinion. I also do believe that Fernandez testified to 2 or 3 of those and insinuated to others. And again, I still believe my client testified truthfully that he made insults after he was arrested. He's also testified that he was angry and upset. I don't believe playing the video. I believe it's way more prejudicial for the probative value has already been determined by the police's testimony.
Ms. Santini?
Your Honor, it's just to show for recollection and credibility, as he did testify, and he had trouble testifying as to whether insults were made, and finally he did come out with, well, maybe 1, and it just shows that that's not the whole story, and he wasn't being forthcoming with that in his testimony.
Judge, even if he's not on trial for insulting a cop, police officers are insulted all the time. If every time a defendant called a cop an asshole or a piece of shit, and they were able to come in and use that to open the door when a defendant takes the stand, I don't believe calling a cop an asshole or even a piece of shit gives rise to this issue.
Well, the purpose of impeachment is to show the lack of credibility of witness.
Correct, but we're also using the credibility of someone hours after a very significant accident, and he did testify that he made insults after. You can testify that he made insults and still be truthful without saying, yes, I called the cop dickhead of the year. The jury gets the point. To bring it in is not only cumulative, it has no relevance to the ultimate issue.
So my memory of Trooper Hernandez's testimony was that he testified that on the way to the jail, Mr. Smith insulted him using derogatory language multiple times. The memory of Mr. Smith's testimony was that he testified that he insulted him 1 time, and that was regarding seeing him in court. And when asked if he insulted him in any other way, he said no.
I believe that this needs to be clarified because we were on that. I believe Ms. Santini rehabilitated with that, stated that I did say I was in the court, and that was the insult in court, and that yes, after he was arrested, he was angry and recalled maybe 1 or 2 insults. That's what he stated to recall. Not recalling others, especially given the accident, does not mean that he's being dishonest on the stand for purposes of impeachment. Obviously, the jury can still weigh his credibility the way they want anyone to do, but I don't believe it's
Ms. Santini?
I believe, I know that we went over this a few times with the questioning because I was trying to get it straightened out. But I believe the main answer was that he didn't insult him, and then there was one insult, and then when I did ask, I believe, after arresting you, are you denying that or are you admitting that you gave insults? And I honestly don't remember.
He said yes, because it was after he was arrested.
All right, so it doesn't sound like we're in agreement, so let me call court smart. Rose, it's Judge Adams. How are you? I'm doing well. One moment. I'm going to go off the record for just a moment while I talk to Court Smart.
And where's your friend's house that you stopped at that night? Where is it located?
Objection, as to user.
Overruled.
Where's the friend's house that you were at that night? Where is it?
That's in
located?
Weston.
Pembroke
It's,
Pines?
no, Weston, Florida. It's off of I-75 and 595.
Didn't you tell Sergeant Nunez that night that you were coming from home?
Yeah, I was originally coming here.
Judge's mischaracterization of testimony, Officer Nunez did clarify both of those points after Trooper Nunez.
Overruled. You may answer.
Didn't you tell Sergeant Nunez that day that you were coming from home?
Well, yeah, my original destination that I had left was home. And on my way towards, over this way, I had made a stop by somebody's house that lives off of 595.
And you mentioned with Mr. Armpriester that you were heading to Sanibel
Correct.
that night. But when you spoke to the officers that night, you did not say that. Is that correct?
Yeah, that's correct. Due to the fact that I had just had an accident, so my mind wasn't all there responding to it. The last thing I remember was that I was leaving in Weston.
In fact, the whole time you thought you were heading towards Pembroke Pines.
No, I was questioned after the impact. So I could have been lost in direction and all kinds of stuff that I know of. Because I'm hearing and seeing it too, and that's the only thing that could have been.
And where do you live?
Where do I live? Pembroke Pines.
And is that where you lived on April 25th, 2020?
Yes.
And how did you end up on, I'm sorry, you mentioned that night that you had missed your exit to the officers. Which exit was that?
That was an exit that I was trying to get off to go to a rest stop or.
Do we need to
just
fast
something
forward, Ms.
general.
Santini?
Hey.
I wanted to take a break before I got on the road again.
You mentioned that you attempted a U-turn. Was that not near an exit?
No, I never really said I was trying to do a U-turn. There's nowhere really to U-turn on there. Right.
You mentioned to
After I got hit, I wanted to go back home to my girlfriend because plans are canceled. No more going over here. Just figure this issue out now.
You mentioned to Mr. Love and to the officers that night that you attempted to do a U-turn. Isn't that correct?
No, I never. I have no reason to tell the driver of the semi truck that I was trying to do a U-turn. I was questioning him why he hit my car.
And you heard Mr. Love testify that he saw your car in the middle of the road still. Isn't that correct?
I heard him say that, but that's not the truth.
So you're denying that your car was in the middle of the road?
Correct.
Are you also denying that you were trying to do a U-turn in the middle of the road there?
Correct.
And Ms. Armpriester went over with you when you were explaining how the crash occurred. Can you please go over that?
That's not a cross question.
Can you repeat the question?
I would like to clarify how the crash occurred with the defendant as he spoke to Ms. Armpriester. It was a little unclear.
Sustained.
With Ms. Armpriester, I believe you mentioned that the front of your car hit something and that was unclear. Can you please elaborate or clarify that?
Objection to the statement of counsel's question. I never asked a question about the front.
Did the defendant testify as to something with the front of the car and with the crash, and that was confusing?
Sustained.
You mentioned you were hit, but you never reported that, did you?
I do have a video of when I had got out.
That's not the question. Did you ever report that night?
Reported?
Tonight?
No, I reported it to the owner of the vehicle that owns the car. I told her
So
so.
did you call 911 that night?
I didn't get a chance to because Lovin said that he was going to do it. And then he threatened me, so that's why.
And did you call your girlfriend that night?
Correct, yes.
I was on the phone with her pretty much the whole time.
And that night, you told the officers that you believed that you were hit in your car in Broward, isn't that correct?
No.
So you're denying that you said that to the officers that night?
Yeah.
That's not nothing in the state in the process of trial testimony.
It's in the
Overruled.
video. Did you also tell law enforcement that night that you were following Mr. Love, and Mr. Love took off and left the scene?
No. Oh, when he originally hit me, he kept going. So I guess that's leaving the scene. He never stopped.
Didn't you follow him after that?
Of course, yes. You know.
Didn't you say you were afraid of him?
I was afraid of him after he threatened me.
So you followed him?
I wasn't gonna
after
let
that?
somebody get away that hit my back of my car. I wanted to get their license plate and so forth.
You told all law enforcement that night that when they asked you how much time passed from the point of the accident to when they arrived, you said 15 minutes, isn't that correct?
15, 20 minutes. Again, my perception of things have been shooken because of the impact itself.
And when did you realize that your car bumper was missing? At what point?
Objection, outside scope of direct.
Sustained.
There was testimony about your back window being blown out and that there was glass in the back seat and in the front seat. Did you also have glass in your hair from that?
I had glass in my head, glass in the trunk.
But did you have any cuts on you from the glass?
Maybe in my head. I can't see on top of my head. But there was glass shards all over me. So.
And you still...
There was glass all over me pretty much.
And after that, you still didn't call 911 just to get medical services?
I mean, he was more worried about doing his investigation for whatever it was who hit me. So he just told me to relax and take it easy for right now. That I look good. I don't have a scratch on me or anything like that. And I trusted him.
But before law enforcement arrived, why didn't you give 911 a call to get medical services after?
Because it happened so fast, man.
Also, objection has to make with Mr. Love, to testify that Mr. Love is calling 911.
Overruled.
Ms. Arthur said in her opening that you were going to visit your girlfriend in Collier County.
Objection, Your Honor, outside the scope of direct. He has no bearing on my direct examination.
Sustained. Rephrase your question.
In direct examination with Ms. Armbruster, you stated that you were going to Sanibel with your girlfriend, and that's where you were heading, correct?
Correct.
But didn't you say that night that you had to work at 6 a.m. that morning?
Objection, the statement of evidence.
It's in the video.
Overruled.
I believe I said I wake up every morning to work at 6 every day, and that was kind of the reason why I've been up 24 hours now at this point to the next day, and then he asked me to conduct that.
So are you denying that you told law enforcement that you had to work at 6 a.m.?
I told him that I work at 6 a.m. In general. That's my working hours, that I wake up every day at 6 a.m. That's the only reason why I would say that, 6 a.m.
Do you have an objection?
Judge, I object to, it's going to confuse the jury, that my client's testimony was that he had worked at 6 a.m. the day prior. It was now 24 hours later. His testimony was not that he had to get up that day at 6 a.m., that he was up the day prior at 6 a.m.
And that's what he just testified to, so, overruled.
And to clarify, you also said that you had to be at work in an hour. To the officers that night.
I mean, at that point, at what time did I say that?
In the video when you were speaking to one of the officers.
I don't recall that. I said maybe I'm gonna have to be up in an hour I should be up in an hour from now to go to work, but I know it's Saturday and there is no work on Saturday, so. Plus I got let off at 12 o'clock during the day.
And I didn't hear Ms. Armbruster ever say that you went to see a medical professional after all this. Isn't that true?
Objection, relevance.
Overruled.
You may answer the question. Did you ever see a medical professional after all this happened?
Of course, yes.
And when was that?
Next day.
this armed officer was asking you if you could hear the trooper all right during the field sobriety exercises. But weren't you standing right next to the trooper when he told you the instructions?
I mean, if you stand out there on a highway and you try to listen to somebody even if they're next to you, it's kind of tough. So I was just getting his direct order.
But were you standing right next to him?
Of course I was standing next to him. He was standing next to me.
So you stated earlier that you were a driver for a warehouse logistics company, correct?
Correct.
So, as you've already stated, you could lose your driver's license for a DUI.
Correct.
So your driver's license is important to you.
Objection outside the scope of direct.
Overruled.
So is your driver's license important to you?
Yes.
And it's important to your job at that time.
Correct.
But when given the opportunity to provide a breath sample, you chose to give up your driver's license rather than provide a breath.
No, that's not how it happened.
But can you answer the question?
No.
You stated that the crash occurred because the truck was riding you. But you told officers that you were in the merged lane. Isn't that correct?
I never told the officer I was in the merge lane.
So you're denying that you told the officers that night that you were in the merged lane?
We were riding next to each other in the
Objection.
merge.
Mr. Smith, if there's an objection, you need to stop the talk.
Okay. Thank you.
Outside the scope of direct and relevant.
Overruled.
So are you denying you told the officers that night that you were in the merged lane?
Objection and proper impeachment.
Overruled.
Please answer the question, Mr. Smith.
I'm confused what you mean by merge lane.
The merged lane that you were coming off of.
Coming off of work. I was driving straight. We were side to side of each other. Never came from a merge or.
So are you denying that you said that night then, that you were on the merged lane?
Yes.
So you keep saying that you don't remember things because of the impact, but you also just stated in direct examination that you had a clear memory of everything that happened that night. Isn't that true?
A year later, yeah, after a time of thinking.
So this far later, you remember everything, but that night, you couldn't remember.
At the moment, no. I was not thinking properly at all. I had just suffered an accident, a tragic accident that I lost my car and so forth. And there was no question to who hit me or anything. It was directed towards something else.
And isn't it true that after you were arrested, you became angry with the trooper?
Objection outside the scope of direct.
Overruled. Any answer?
I was frustrated because I felt he kind of made me feel like I was trusting him, and he turned it around to not be that.
Isn't it true that you blamed the trooper for your arrest that night?
Not doing his job fully. That's opinion of mine. I wasn't being directed to him in his, uniform, but I was just saying in general. He could have did better in figuring out what the issue was.
And yesterday, you saw the video from Sergeant Miguez's dash cam, correct?
Yes.
And in that video, you were overheard telling the deputy that Mr. Love called you a cracker, right?
Objection outside the scope of direct and relevant.
Overruled.
Would you like me to repeat the question?
Excuse me?
In that video, you overheard that you were told the deputy that Mr. Love called you a cracker. Is that right?
Yes, he's calling me all kinds of names.
And you said back to the deputy that you don't treat people that way, right?
Yeah, so
However, you did treat the trooper after you arrested differently. Isn't that right?
this is 2 or 3 hour spans in between of realizing what's going on and knowing what's going on and just the outcome of it.
So after you told the deputy that you don't treat people that way, didn't you insult Trooper Hernandez several times that night?
Objection, Judge, outside the scope of direct.
Overruled.
Can you repeat the question again?
So after you told the deputy that you don't treat people that way, didn't you insult Trooper Hernandez several times that morning?
No, I never insulted him.
So you're denying ever insulting Trooper Hernandez?
I mean, insulting as in, like, telling him something after he arrested me?
Yes.
After he arrested me, yes, but beforehand, no.
So
I was upset. Anybody would be upset after try the hardest to do something. Okay.
So you're not denying that you insulted the trooper several times
I mean,
after arresting you?
I wouldn't say several times. I might have said one thing or two things, but that's just out of being human, I guess, and dealing with the situation, that the outcome wasn't what you expected.
So just to be clear, so you are admitting that you made insults to Trooper Hernandez after?
No, they weren't insults. They weren't insults. We were just talking. He was talking back to me.
Thank you, sir. No further questions.
Any redirect? All right. Ms. Armpriester, do you, where's your position after the playback?
Even after the playback, I tried to write down as much as I can. I do believe that when he was asked and clarified, and his response was later when I realized what was going on, and then he clarified after he arrested me, yes, I was upset. Might have, to him, what he was saying wasn't an insult to him, it was name calling, albeit I did clarify that with him, but I even have a quote that he wasn't denying. It might have, I'm human. He even did say to Ms. Santini, when I believe the question was posed, so you would agree that, did you insult him? And then the clarification came, after he arrested me, yes, I was upset. So I do believe that the question was truthfully answered, however, it continued to go down that path. However, Mr. Smith was honest. I don't believe even for impeachment that opens the door to his credibility to play that video in front of. I think taken in totality with my direct in terms of the cross and the way, even rehearing the questions and juxtaposing my notes prior to them now, I do believe that Mr. Smith answered honestly and that the questions were not as clear as they could have been.
Ms. Santini?
The main question posed was, did you insult Trooper Hernandez several times? And we danced around that, but what came out was, when I did follow up with, so are you admitting to insulting him? And he says maybe one or two insults. And then I think the very last statement was, they weren't insults though, we were talking, he was talking back to me. So the question is several times, one or two is not several times, and that's in contradiction. And also they weren't insults when clearly they are insults.
So the order I have is you asked if he insulted the trooper several times. No, never. So are you denying that you ever insulted him? Well, I mean, I was telling him something. You mean after I was arrested? Yes, after I was arrested. So you're admitting that you insulted the trooper. Well, I wouldn't say I did it several times, maybe one or two. So you're denying that you insulted him several times. Well, not insults. So based on Mr. Smith's testimony, the court rules that he has opened the door to impeachment with the insults as noted by the court earlier. Now, let's talk about how to get those in front of the jury, if that's your plan.
Yes, Your Honor.
Obviously, we don't have time for you to do a redacted video, so I think the best thing to do would be to question the trooper about the insults that the court specifically found were made. And just for the record, an insult is defined, Ms. Armpriester and Mr. Smith, as a disrespectful or scornfully abusive remark or action. And so I think the 8 that were outlined by the court fall in line with that.
Your Honor, the 8 that were outlined by the court, I would ask that the state not, Trooper Hernandez hasn't been here, I would just ask that, trying to figure out how to phrase this as well, with what the insults that were heard on the video, in purposes of direct, I would ask that the trooper not be made aware that Your Honor had independent findings of 8 specific insults before his testimony. And I'm not sure if the state's already spoken to him about that.
We've been here, Your Honor.
Oh, we all do our cell phones.
Well,
What he's going to testify to is what he's going to testify to. What we've discussed and what Your Honor's 8 individual findings were, I would just ask that Mr. Hernandez testify independent of what we discussed in court.
well, I would agree that the state cannot discuss the findings of the 8 insults with Trooper Hernandez because he's under the rule of sequestration, and this is a sidebar, and kind of. And so I would agree with the defense. However, that doesn't preclude the state from playing the video for him during, a recess before calling him as a witness. All right, so your motion to not allow the state to discuss the findings by the court made on the record regarding the insults is granted. Anything else we need to address?
Yes, Your Honor. Your Honor, there were statements made during the defendant's testimony regarding timing, when he had to go to work. Ms. Armpriester and I did agree to redacted terms for the CCSO video already in evidence. That did not include those statements. We would like to play those. I don't know if there's an objection to that or
Your Honor,
not.
this is getting out of hand. Mr. Smith clarified that on work. It's been very clear.
Your Honor, if I can finish prior to being interrupted.
You did ask Ms. Armpriester.
All right, Mr. Rabb, will you finish?
Thank you, Your Honor. Your Honor, I would argue that the rules of evidence are not getting out of hand. We are allowed to rehabilitate any of our witnesses. Our witnesses made testimony that the defendant told them certain statements. We would like to rehabilitate them by playing portions of the video that relate to his timing of going to work. The fact that he was just told he was in Naples relating to his ability to understand where he was. The fact that he was at his friend's house talking shit and doing donuts in a golf cart. We believe that all of that is relevant to impeaching the defendant and to rehabilitating our witnesses to what they said.
Ms. Armpriester.
Your Honor, to rehabilitate a witness, their witness would need rehabilitating. It's not their witness that needs rehabilitating. They're seeking to essentially Monday morning quarterback after my client's defense. They do get a rebuttal case. This is not that time. And if there was an objection or any impeachment that needed to be done, it's completely untimely as it relates to when my client went to work. And we just re-listened to it, and what his statement was, I get up at 6 every day for work. I've been up 24 hours. I was up yesterday at 6, trying to figure out what time it was, realizing it's nearing 6 a.m. I should be getting up for work in nearly an hour, meaning that's his habit, routine, where he goes. Ultimately, this is a very untimely objection that should have been made during my direct, or it should have been impeached timely during cross. But now during this, especially having just listened to it, that is Mr. Smith's testimony. They had ample opportunity to cross him, and they can bring whatever they want in their rebuttal case, but based on his testimony does not now mean that this video, which in no way has any probative value to the elements of DUI, make it relevant.
Any response?
Your Honor, first and foremost, the state would play those videos in our rebuttal case with our witnesses. This is just to save time since it already is 1:40. as it relates to that motion. Again, Your Honor, the fact that the defendant testified, he should be treated as any other witness. His testimony with the jury is incensed doubting credibility on what our witnesses were told or heard. They should be allowed to be rehabilitated and the witness impeached at the same time with that evidence.
Your Honor, I don't believe the full video coming in the rebuttal case is acceptable, given that there's no redactions when the court just ruled that Trooper Hernandez would be able to testify to it. I will not agree to this video being played in its unredacted form.
Your Honor, there has been a pretrial ruling regarding anything being taken out of the CCSO video specifically. I do understand the pretrial motion as it relates to the FHP video. As it relates to this specific video with CCSO, it is about a 6-minute portion of the CCSO video.
Shouldn't you have used the video or the audio to impeach Mr. Smith?
Can I use that?
No, shouldn't you have while you're during your cross?
Your Honor, because it wasn't part of evidence already entered into evidence, since it was not included in the original redacted version, we would need Sergeant Munoz to come back to appropriately enter that evidence and to authenticate it.
Well, you can impeach someone with anything. It doesn't have to be in evidence.
Your Honor, apologies, Your Honor. My understanding was that we would be able to submit that evidence once our next opportunity to admit evidence came up. That would be in our rebuttal case. That's what we intended to do.
Impeaching someone with a prior recorded video isn't admitting it into evidence.
Nevertheless, Your Honor, I don't think there's anything inappropriate about us admitting it with Sergeant Munoz, the relevant portions.
So, defense's motion is granted. The way to, obviously you're allowed to question your witnesses as to things that you believe that Mr. Smith said that's impeachable, but you can't impeach Mr. Smith with a video through another witness.
Understood, Your Honor.
Okay.
Your Honor, for clarification, in the rebuttal case, we have not agreed to an unredacted or other video being played. If it's another exhibit beyond 2 or 3, I would ask for a heads up and time to hold redactions with the state, because there are other issues that are still upheld in pretrial motions.
Do you intend on introducing any videos in your rebuttal case?
Your Honor, based on your order regarding the FHP video, I imagine that you are precluding us from playing the relevant portions with redactions. If you are also precluding us from the CCSO video, then I do not believe there's any other video.
Well, I'm not precluding you from doing it. I'm just telling you what the purpose of impeachment is. So, if you have a reason to introduce more evidence, that's what you'll have to bring out. But as far as I'm not advising you what you can or can't do on rebuttal. So, court will be, we're going to take a 15-minute recess. Do we know if the jury's checked in? Okay, so we're going to take a 15-minute recess, and we'll come back at 2 o'clock to call the defense's next witness. Okay, all right.
Argument in law on the record as it relates to the impeachment of the defendant. I did take opportunity during the 15-minute recess to research something that I believe the court can take my claim valuable.
Go ahead.
Judge, in looking at what it is we were deciding as to whether or not my client insulted or didn't the trooper, and looking at the jury instructions and the elements of this case, the state needs to prove if my client was in actual physical control or if his normal faculties were impaired. As such, his insulting the trooper is a collateral matter. I'm reading from Earhart's, and there is case law, Judge. I'm reading from section 608.1 on impeachment of witnesses, and pursuant to, ironically, Smith v. State, 754 Southern 2nd, Florida 3rd DCA 2000. Judge, particularly when attempting to impeach an answer that counsel obtained during cross-examination of a witness called by opposing side, here the state trying to cross Mr. Smith, called by me. Counsel should remember that if the testimony during cross-examination relates to a collateral matter, no extrinsic contrary proof, for example, prior inconsistent statements, is admissible. Your Honor, I would argue that it's a collateral matter whether he insulted the cop or not. It doesn't go to an ultimate issue of the case. And in citing Smith v. State, it states that it was abuse of discretion to permit proof of a statement made earlier. Quote, the subject matter was clearly collateral as was not relevant to the litigation at hand to establish any fact or consequence. Therefore, it is relevant for a purpose other than merely to contradict a court testimony of the witness. The statement was inadmissible as a prior inconsistent statement because the statement was as to a collateral matter. So being that what the state is trying to impeach Mr. Smith on does not go to an ultimate issue of the case, i.e. driving under the influence, I would argue that impeachment on a collateral matter is not proper.
608 what?
608.1 is towards the very end. I am reading from a 2016 edition. It is page 625. May I be seated?
You may.
What was the page, 625?
On my edition from 2016, I have two copies if you want to borrow mine. It starts with the testimony of a witness, page 625, corresponding with footnote 20. The case law I cited is in footnote 22.
What was the footnote, sorry? Sorry, what was the footnote?
The specific one I cited.
Or, I'm sorry, the citation for the case.
For the case or for the?
For the case.
You're citing to Smith v. State, 754 Southern 2nd 54. Is that correct?
Yes.
All right. Any response?
Yes, Your Honor. I think the court has already ruled on the relevancy of this matter as it relates to one of the substantial prongs of DUI when you previously ruled that we were allowed to question Trooper Fernandez on comments that were made to him on the jail transport and allow the trier of fact to determine whether or not that relates to his impairment. Therefore, this does relate to a substantive matter, not a collateral matter. And in addition to that, Your Honor, I do believe that there are, and I'm quoting from Foster v. State, 869 Southern 2nd 743. There are two types of evidence that pass this test: facts that are relevant to a particular issue and facts to discredit a witness's testimony. In this case, the defendant stand again, gave inconsistent testimony with what he previously stated. Not only does that go to his memory and recollection of the issues, his credibility as a witness, but it also does go to a substantive matter.
All right. Ms. Armpriester, in Smith v. State, the difference between that case and the case that we have here is that there was not an in-court statement made. It was an out-of-court statement made 5 years prior to the offense. And so the statement was inadmissible as a prior inconsistent statement because the statement was not inconsistent with any in-court testimony of the witness. Here we have in-court testimony of Mr. Smith that is inconsistent with the events that occurred during the jail transportation.
Yes, Your Honor, but it also goes on to say, I believe Smith cites a case called Correa, and even if that's accurate, it's impeachment on a collateral matter. It's not as to the testimony that happened. The state's trying to do this for impeachment, so impeachment on the collateral matter is different. But even in citing 2654 Southern 2nd 952, that case, in your trial was required because the state was allowed to introduce extrinsic evidence solely to impeach defendant's witness on immaterial collateral matter inquired into cross-examination. The court in that case ruled minor discrepancies in a witness's testimony or between witnesses can be expected in all cases, especially if the testimony is not manufactured by the witness. There's a distinction between the wide discretion allowing cross-examination on collateral matters, and there's limited discretion afforded to impeachment by extrinsic evidence on matters inquired into on cross. Judge, in this case, whether or not he insulted the trooper in no way goes to an ultimate issue. So to impeach him on a collateral matter, to then the 403B test comes in, we're already have law that says in Florida you cannot impeach on a collateral matter. And then if the court were to allow that through video when the trooper is here, under the 403B standard, the danger of prejudice far outweighs any probative value when impeaching on a collateral matter, when, as law in Florida states, minor discrepancy. This is a minor discrepancy that does not go to if he was in actual physical control of the vehicle or normal faculties impaired.
Anything else, Mr. Ram?
Your Honor, I'll just simply say that I don't believe that discrepancies, this is not a minor discrepancy. Recollection is not a collateral matter. How an accident is caused in a DUI damage crash, that would be a collateral matter outside of alcohol. If someone is trying to argue that brakes failed, perhaps this is not a collateral matter.
Judge, my understanding, and I looked it up in Black's Law Dictionary, is that collateral is secondary, not as how the accident happened in this case is anything but a collateral matter. Whether or not my client assaulted a police officer after being arrested on his birthday is not a collateral matter.
So a prior statement must either directly contradict or materially differ from the trial testimony of the witness, and that's what we have here. Your objection is overruled. All right. Are we ready for the jury?
Yes.
Okay, let's bring in the jury.
Miss Diaz with your witness, and she's
344.
Okay.
actually Miss Diaz is up in our UAE.
Well, you'll have to call up there to tell her to come down.
I don't have her phone number. Go get it. She was not affordable with her.
Yes.
Judge, can I just clarify, there was nothing precluding us from playing a portion that we played for
Can we
you?
have this conversation when I come back? Or I can wait.
Mr. Pershore, could you get Ms. Diaz? Or call your office to send her down? Thank you. And I'm sorry, Mr. Rabb, what was your question?
Apologies, Your Honor. My my question was simply just to clarify, you did not give an order precluding us from playing any video. It was simply a concern you had for the redaction. So in other words, if we played a piece of the video that we played for you and not be admitted into evidence.
Correct.
Okay, thank you, Your Honor.
Will the defense be afforded an opportunity to see what portions they're going to play since we agreed on redactions prior and now a portion of that's on the end?
The way that I understood Mr. Rabb's question is he's not admitting it into evidence. He's playing it for purposes of impeachment.
That's correct, Your Honor.
I understand. I'm just asking what portions he intends to play so I can be prepared as courtesy. Since we did agree on what would be played and now we're.
I'll leave that between the two of you because it's, you know, it's for impeachment. So I'll leave it at that. Yeah, just hold them. Can you just step out until we call you in? Okay. All right, let's have the jury go in.
Your Honor, the jury.
Thank you. All right, thank you. You may be seated. All right, we have all members of the jury present and accounted for. Thank you. I hope you had a nice lunch break. We're back on State of Florida v. Garrett Berg Smith, case number 20 CT 777. All right, defense, you may call your next witness.
Yeah.
Good afternoon.
Good afternoon.
Good afternoon, Ms. Diaz.
Good afternoon.
Can you please state your name and spell it for the court reporter?
Bianca Diaz, Bianca. Last name Diaz, Diaz.
And what is your involvement with this case?
I'm Jared's girlfriend.
And beyond being, how long have you been his girlfriend?
8 going on 9 years.
And go ahead and get it out of the way. Even though you've been dating him 8 years, are you here to tell the truth today?
Absolutely.
And even though you love Mr. Smith, you are telling the truth?
Yes.
And what is can you tell the jury the relationship between you and Mr. Smith and the silver Nissan that you both shared around April 2020?
So yes, we shared the silver Nissan.
And did you have access to it as much as he did?
Yes.
And was the car in your name?
Yes.
But he had full permission to drive it.
Right.
And when's the last time you had driven that car?
From that day?
Yes,
Like
prior to.
Probably the day before.
And what did you use that car for?
Relevance.
Overruled.
What did you use that car for?
Drive around. I would do Postmates and DoorDash because it's a smaller vehicle than.
Postmates and DoorDash.
It's a delivery service for food.
And explain more how that job fit into your schedule, please.
Okay, so I'm a preschool director, so I work from 9:30 a.m. to 6:30 p.m. and when I get off, I do DoorDash sometimes and Postmates and on weekends as well.
And you utilize your car for that?
The Nissan Altima, yes.
And I want to draw your attention to April 25th, 2020. Who had the car that day?
Jared.
And did you speak with him that day?
Yes.
And where was he, to the best of your knowledge, when you spoke with him?
At the time of the accident, or like in general that day?
Yes.
Well, he was working that day, and then he got off work.
Overruled.
You can answer.
Okay. He got off work and he came to the house. We had dinner, and he invited me over to his friend's house. I did not go because we had to be up early to go to Sanibel in the morning. And, well, I had to be in Sanibel in the morning. And
Now, when you were having this time with Mr. Smith, did he sound normal to you?
yes,
And anything stick out in your mind as it related to his overall demeanor?
I was concerned of his well-being
When?
after the accident took place.
But I mean prior to.
Oh, prior? No, he was
when he
fine.
was going to his friend's house and you declined the invite.
No, he was normal.
Now, did you speak to him again that night?
Yes.
Approximately what time?
Around 11:30.
And when you spoke to him later that night, how did he sound?
Fine.
And did you speak to him on the early morning of April 25th?
Yes.
And what was the context of that conversation?
He was telling me about the accident, about what happened.
So he called you to tell you?
About what happened.
And
Overruled.
And when you were speaking to him during that conversation, did he sound different than he did before?
When I spoke to him after, in the early morning?
Yes.
Yeah, he was scared. He sounded hurt, anxious.
Did he sound, strike that. Have you ever been around Mr. Smith when he's drank alcohol?
Yes.
Do you know how he behaves when he's had alcohol?
Yes.
With that knowledge, when you spoke to him after the accident, did he sound like he had been under the influence?
No, he sounded normal, just upset, frazzled.
And to the best of your knowledge, while you were on the phone with him, did you in any way think he was impaired from alcohol?
No.
And to the best of your knowledge, had he been drinking that day?
No.
And when you were around him earlier that night, did you see him consume alcohol?
No.
Earlier, it was testified to that, strike that. Do you have a medical marijuana card?
Yes.
Relevance.
Overruled.
And with that medical marijuana card, do you legally purchase products?
Yes.
And earlier when you were using the car, had you gone to the dispensary to get product?
Yes.
And is it possible that, strike that. Do you have habit of leaving some of your medical marijuana in the vehicle?
Not particularly, but it could have happened.
And to the best of your knowledge, does Jarrett smoke?
Yes.
And was he smoking on that day?
No.
And to the best of your knowledge, was that alleged baggie yours?
Yes.
And are you taking responsibility for that?
Yes.
Is there any other involvement that you have with this case?
No, other than it being my car.
I have no further questions.
All right, thank you. State, any cross?
Yes, Your Honor, thank you. Good afternoon.
Good afternoon.
How are you?
Well, thank you.
You mentioned that you and the defendant share a vehicle, or
Yes.
shared a vehicle at least at the time, and that you were going to take a trip to Sanibel that weekend,
Yes.
I imagine for his birthday. And I know Mr. Smith had previously met, or I don't know if Mr. Smith had previously mentioned, do you share a child between the two of you?
Yes.
Okay, so you were going to go as a family to Sanibel?
Correct.
All right, in the same car, I imagine?
No, he was gonna go first and then I was gonna meet up with him.
He was going to go at 3 in the morning to
Yes.
Sanibel? That was
Yes.
the plan? To go to Sanibel at 3 in the morning?
Right.
Okay. And then you guys were going to follow him later on
Yes.
the next day? All right, and when Mr. Smith was in the back of a patrol vehicle, do you remember that conversation with him?
Yes.
Okay, and part of that conversation, I believe he told you he had gotten into a crash and he was in the back of a cop car. Do you remember what your response to that was?
What happened?
What happened? Did you say anything else?
Probably, yeah.
Yeah. Were you surprised that he was in the back?
Yes, definitely.
And then he told you where to pick him up, right?
Well, actually, we were trying to figure it out, and the officer got on the phone. Officer or Trooper Hernandez, I'm sorry. He got on the phone, and at first he told me he was, I think, in mile marker 63. So I was initially on my way there to pick him up and to get the car, of course. And then he moved to another mile marker, and when I tried to figure it out, he said he moved for his safety.
Would it surprise you that Trooper Hernandez never saw the defendant at mile marker 69?
Sustained.
Ms. Diaz, on the phone conversation when Mr. Smith was in the back of the patrol vehicle, he told you to pick him up at a gas station, correct?
No.
He didn't tell you to pick him up at a
No,
gas
he was on the
station
side of the road.
off of Weston? That's not what he told you?
No.
He didn't?
No.
Okay. No further questions, Your Honor.
All right, thank you. Any redirect?
Yes.
Okay.
Ms. Diaz, how long were you on the phone with Mr. Smith after he was involved in an accident?
Almost like the whole time. I want to say like,
Over an hour,
yeah,
maybe even 2?
yes.
And during this period of time that you were on the phone with him, how many times did the story change of where Mr. Smith was going and what was happening?
No, just like once.
But at first you weren't sure if he was going to do sobriety exercises at a gas station or the toll plaza, correct?
No,
And you were just trying to figure that out.
right.
So when the state asked you on cross about your knowledge and what was told to you, is it fair to say that you were given a lot of information that night
Yes,
and that you were trying to figure out where to find your significant other and how to ensure his safety?
correct, yes.
And what was your goal for trying to ensure the safety of Mr. Smith while he was in police custody?
I had 2 goals. One of them was to make sure he was okay and safe and come back home. The second goal was to recover my car.
And when you were on the phone with Mr. Smith and for over the 2 hours, at any time did it cross your mind that he was anything but shaken from an accident?
No,
And at any time, were you, strike that. I have no further questions.
All right, thank you.
Nothing from the state, Your Honor.
All right, thank you. May this witness be released?
Yes, Your Honor.
All right, thank you.
Thank you.
You're released.
Your Honor, may she wait in the courtroom now?
She may.
Is he upstairs? So bring him down here.
All right. Defense, you may call your next witness.
Judge, at this point, the defense rests.
All right, thank you.
Your Honor, so we'll be calling Sergeant Jose Munoz.
All right, Sergeant Munoz.
Since he's here, have Teddy bring down Madison. I do need the CD though.
Your Honor, I'm not sure procedurally before the state goes into rebuttal. No, I will bring you.
My computer.
I'm sorry?
I was going to take a renewed motion for judgment of acquittal, but I will do that at the end of the state's.
Does not need to occur now. Procedurally.
Yes.
Judge, may I maybe excuse the jury to renew my motion?
Yes. All right, members of the jury, we're going to have you go back to the jury room for a little bit while we discuss some matters before the state begins its rebuttal.
All right, for the jury. Jury's clear.
All right, thank you. You may be seated. All right, go ahead, Ms. Armpriester.
Judge, I renew my prior motion of judgment of acquittal, and again, viewing the light in most favorable to the state, they have yet to prove that either element of the DUI. Judge, it did come back out through talks of the trooper and through my client. The first element cannot be met, that Mr. Jarrett Berg-Smith drove over with an actual physical control of the vehicle. Actual physical control is defined in the jury instructions as defendant must be physically in the vehicle and have the capability to operate the vehicle, regardless of whether he was actually operating the vehicle at the time. So, Your Honor, there's a testimony that the car was inoperable. It had run out of gas. The trooper verified that. Even it was verified that whatever accident this car was a part of, that the gas tank was hit and it had run out of gas. Either way, it was not operable. I believe I have things on that. I can point to a specific issue on that. That's element one. The state bill on element one. The car was not operable, and not just Mr. Smith, he said it, law enforcement did. As it relates to element two, while driving or in actual physical control of the vehicle, Mr. Smith was under the influence of alcohol and beverages to the extent that his normal faculties were impaired. Your Honor, I know I don't have to remind you what normal faculties are. However, for purposes of the record, they include but are not limited to his ability to see, hear, walk, talk, judge distances, drive a car, make judgments, act in emergencies, and in general perform the many mental and physical tasks of his daily lives. Judge, the state also fails to meet this element. We saw him walk, we saw him talk. We may not have liked the things he said. Some of them that we heard today were not nice. However, they do not go to the element of DUI, and they do not go to impairment. There has been no evidence put on, aside from the fact that perhaps 1 year was consumed, that Mr. Smith was under the influence of alcohol, or that his normal faculties were impaired, but he certainly was not under the influence of alcohol to the extent that his normal faculties were impaired. Judge, he acted in an emergency. We just heard from Ms. Diaz that he called her. It's on video. It's over an hour and 45-minute long conversation. That was him acting in an emergency. Walking and talking to the officer. We saw it numerous times. I replayed it, the state played it. He was trying to work with Trooper Hernandez on how to understand how to do these things. He walked to the car, put his phone, walked right back. That's a normal faculty. Your Honor, as such, I would argue that the state has not met its burden. This should not go to the jury. They cannot prove either element of 316.193. As such, the defense requests that you grant our motion for judgment of acquittal.
All right, thank you. State, any response?
Yes, Your Honor. First and foremost, as it relates to inoperability, inoperability is not a defense where there is not significant mechanical repair that needs to be given to a vehicle. In this case, the trooper stated that the vehicle was out of gas. I will state, or I will cite Hughes v. State. Excuse me, Your Honor. 943 Southern 2nd, 179, Florida 3rd DCA, 2006. Hughes v. State. 943 Southern 2nd, 176. The rationale for applying the reasonably capable of being rendered operable standard is due to the recognition that the law in this area is preventative in nature. Its purpose is to deter intoxicated individuals from getting into their vehicle with passengers, and enables law enforcement officers to apprehend intoxicated drivers in this state, where a vehicle could be operated with the aid of an outside agency, such as filling a vehicle up with gas, as stated in State v. Conley, 35, Florida Supplement. Second, 26, Florida 19th Circuit, determined a dismissal based on inoperability would not be improper. Further, in both Cloyd and Hughes, they describe several cases of motor vehicles running out of fuel, dead batteries, flat tires. None of those determine the vehicle to be inoperable. In this case, Your Honor, the state believes that there is sufficient evidence to send this matter to a jury as it relates to element number 1, as it relates to element number 2, normal faculties. I think there is a substantial amount of evidence that the state has presented to suggest that this is a matter for the prior fact. In regards to second JOA, when there is a discrepancy between the defense's case and the state's case, it is proper to send it to the jury.
Great response, Judge.
Yes.
Judge, is it akin to the case where I could pull it up that Mr. Smith merely ran out of gas? His gas tank was injured, so to say, where all the gas leaked out, rendering the car inoperable. Trooper Hernandez testified to that. And by definition under statute, actual physical control means that the defendant must be physically in the vehicle and have the capability to operate it. The car had to get towed away, and it goes on regardless of whether he is actually operating the vehicle at the time.
Your Honor, the car was towed away because the defendant was under investigation for DUI in addition to the vehicle running out of gas. Additionally, Mr. Love stated he saw the defendant driving the vehicle. That I'm aware of, there are no places to pull off to the side of the road that Mr. Smith could have received or consumed any type of alcohol from mile marker 69 to mile marker 90. His vehicle died on mile marker 90. It was clear from the witness testimony that he was, in fact, in physical control of his vehicle, driving, in fact, and the defendant admits to driving that vehicle when he attempted to make a U-turn on I-75.
Yeah, he denied it.
Okay. All right. The court finds that there's sufficient evidence for both elements of the offense of driving under the influence. The officers testified, multiple officers testified to the odor of alcohol, bloodshot, watery eyes, slurred speech, behavioral and emotional extremes, as well as the field sobriety exercises performed by Trooper Hernandez. As it relates to the driving, Mr. Love testified that Mr. Smith was the driver of the Nissan that was later discovered by Officer Muniz, who testified that he saw Mr. Smith exit the driver door. Mr. Love also testified that after the initial encounter, Mr. Smith drove away from that encounter toward the west on I-75, where Mr. Smith was later found around mile marker 89, west of mile marker 63, where Mr. Love met with Trooper Hernandez. So in light most favorable to the state, the motion is denied. All right. Anything else before we call the jury back in?
No, Your Honor.
All right, let's have the jury back in.
Oh, Your Honor, sorry. Based on that ruling, the state would preclude the defense of inoperability during argument. Or, I'm sorry, the state would request that defense be precluded from arguing inoperability.
Ms. Armbruster.
I'm not going to agree with that, Judge. The car was inoperable. The trooper testified it was inoperable. I believe I specifically asked him that. And he has stated that it was due to a gas issue.
You have the case law that you cited to Mr. Ram.
Hughes, Your Honor? Is that what you're referring to?
Yes.
It was Hughes v. State, 943, Southern 2nd, 176, 3rd DCA. As well, it wasn't part of my argument, Your Honor, but I have another site if you'd like.
Hughses.
Huges. Sorry. I have Hughes, Hughes, sorry, Your Honor. Second for the supplement case as well, Your Honor, that I cited.
Is the site to Hughes 943 Southern 2nd 176?
I'm sorry, sir. Yes.
Yeah, I would only differentiate that we're talking about a pilot to a commercial aircraft versus with a very high PAC. I would argue that this case should apply to this car.
Your Honor, additionally, I'm going to butcher the last name. Feliciano versus Department of Highway Safety Motor Vehicles, where a tire was even missing on a vehicle and another was flat. There was a gouge in it that was not determined to be inoperable, but I believe State v. Conley, which is 35 Florida Supplement, 22nd Florida 19th Circuit, is the one that I stated. Lack of fuel, dead battery, flat tire.
I don't think it's necessary. It's just telling me with a citation. How do you spell Connolly?
Conley.
Thank you.
Yes, sir. All right, down for it.
I'm going to reserve ruling on your motion to exclude the inoperability from defense's closing. Just for future trials, it would be helpful if you brought copies of case law to the court. All right. Anything else?
No, Your Honor.
Okay, let's bring in the jury. Thank you. Maybe seated. All right. We have all members of the jury present and accounted for. Thank you. All right. State, you may call your first rebuttal witness.
Yes, Your Honor. State recalls Sergeant. Yes. And Clark.
May.
Thank you, Your Honor. Sergeant, thank you again for being here.
Sure.
Sergeant, going back to the night of April 25th, or the morning, I'm sorry, of April 25th, 2020, did the defendant ever mention anything about going to Sanibel?
Going to, excuse me, where?
Sanibel.
I don't recall.
And did the defendant ever mention anything about his employment?
I remember vaguely something about having to work, but
Do you remember when he said he would have to go to work?
I can't recall. It might have been he said he had to be at work. He had to get up for work the next morning or something, but I honestly can't recall it.
And Your Honor, may I approach?
Yes.
Thank you. Showing counsel, on behalf of Sergeant.
We approach. Overruled as to your first objection, sustained as to foundation.
Sergeant, if you were to, you did mention previously that your interaction with the defendant was recorded on video.
Yes.
If you were to watch, personally, if you were to watch,
Objection, Your Honor, still improper foundation. The witness stated he did not recall.
Overruled.
if you were to watch a copy of a portion of that video, would that refresh your recollection as to what the defendant stated about his work?
Yes.
Your Honor, may I?
You may.
Thank you. Do we have headphones? We actually do.
Sure. It's fine.
Thank you.
Yep.
Thank you, Your Honor. May I resume?
You may.
Thank you. Sergeant, did viewing the video refresh your memory of the statements that the defendant made?
Yes.
And as it related to his employment, what time did he say he had to be at work?
At 6 a.m.
And how long did the defendant believe that was from where you were?
In an hour.
Thank you. I you. Now, holding those big off S is the unredacted version. Sergeant, for authentication purposes, do you recognize what saves Exhibit 5 is?
Yes.
And what is that?
It's the in-car video of my patrol car.
And is it redacted or is it full version?
It's a full version.
And how do you know that to be the case?
Those are my initials on the back of the sleeve, and I've reviewed it.
And is this a true and accurate copy of your document?
Yes.
Thank you. Your Honor, will you publish my
Any objection?
I would like to know.
Your Honor, the video is being used for impeachment purposes. It will not be entered into evidence. 1 hour, 13 minutes and 1 second, 1 hour, 14 minutes and 15 seconds.
All right. The noted portions will be admitted and played.
I believe that you can correct this more audio.
All right.
Yes.
I told you, the insurance.
Yeah, but like the insurance is gonna be like, oh, it's Amazon.
Nothing to do with it. Amazon has insurance too.
Oh, you know, I have a word, confidential, you know, this is fucking me up. Psychologically, like, how am I gonna get to work?
Listen. You're gonna figure it out.
No, bro.
You're gonna figure it out.
You're gonna go 6 in the morning, that's an hour.
You're gonna figure it out. You'll be fine. I'm sure they'll understand. I'm sure they'll understand. They're just gonna make that work. There's some things you can't help.
Like, oh, and they smash my shit, and they come out and war, and it's to me like, yo, what the fuck? You serious? Get the fuck out of here.
Yeah.
That's why I'm fucking left.
Yeah.
Oh, you fucking grind me, bro. My house, like, hold on, I'm gonna get out. I'm gonna go to the fucking boy. Where am I going? Who told me I was going to fucking Naples?
Go ahead.
Sergeant, my final question. That evening, did the defendant appear to have any idea of where he was?
No.
Thank you. No further questions, Your Honor.
Any cross? All right, thank you.
And yeah, Richard, you're done. Oh, never mind.
You stated that yesterday Mr. Smith's car looked like a grenade went off. Do you still stand by that today?
Yes.
And after someone's been involved in an accident that looks like that, is it common that they might be a little confused and disoriented?
If they were in the vehicle when it occurred, it could be possible, yes.
And what we didn't hear it on the video prior to your recollection being refreshed. But I believe you testified to it yesterday that Mr. Smith had stated that he usually gets up at 6 a.m.
I don't know if, I don't recall him saying that. He usually gets up at 6 a.m.
because he goes to work at that time.
I think he said, I need to be at work at 6.
And do you recall him saying that he had been up since 6 the night before?
I don't recall that.
But he had told you that he had been up and was driving over.
I don't recall that either.
Well, we just heard it on the video that he was coming from Broward. Do you recall that?
Specifically, what part are you talking about? The part we just watched?
Any of it. Any
What we
of
just
your
listened to?
Even yesterday on direct, do you recall that Mr. Smith stated he was driving over from Broward?
He's from Pembroke Pines or Weston area, yes.
Okay. And being a Collier County Sheriff, you're familiar with the road signs on Alligator Alley?
Fairly familiar, yes.
And when you're heading north on I-75, often North Naples is what it says?
Sure.
And Naples happens to be on the way to Sanibel, isn't that true?
Yes.
And in your training and experience, when people are in the back of the squad car, whether they've been in an accident or in any type of altercation, a lot of times people do get emotional.
Yes.
Which is why you were attempting to provide some comfort with saying that it would work out.
Yes.
So it's not uncommon for someone in my client's position to be emotional or disoriented.
I mean, emotional, no, it depends on the circumstance. So they're not, just because in the back of a patrol car doesn't mean they're going to be emotional or disoriented. It just depends on why they're there or why we're there.
In this case, did it surprise you that he was emotional?
Yeah.
Why?
Just the length amount of time that we had been there standing on the side of the road, and he would be very calm, then he'd kind of get excited, and then he'd go to emotions, kind of was through the whole spectrum of emotions.
When he was in the back of your car, did it surprise you that he was emotional?
Not really.
And when he was having difficulty recalling and seemed disoriented, is that reasonable based on the status of his Nissan looking like a grenade went off?
Again, no, I don't think so.
No further questions.
Right.
For redirect, Your Honor.
All right. Is the sergeant excused?
He will be retained, but I know he's close by.
Okay. All right, you're still under subpoena. Yes.
May I just, it is not being admitted into evidence, but for purposes of the record, may I give the exhibit that we use for impeachment?
Yes.
Thank you.
All right. State, you may call your next rebuttal witness.
State, I'd like to call Trooper Hernandez.
You solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth.
I do.
Good afternoon.
Good afternoon, Miss. Oh, sorry. Oh, can you turn your stuff upside down, please? Thank you. Good afternoon, Trooper Hernandez.
Good afternoon.
On the way, or I'm sorry. You testified on your direct examination with Mr. Rabb earlier that the defendant insulted you several times during your transport to the jail. Was that captured on your dash cam video?
Yes, it is.
Showing clothing counsel statement before. May I have a witness?
You may.
Do you recognize this?
Yes,
This is, sorry, state exhibit 4. Is that your signature there?
that is.
And did you review this video prior to now?
Yes,
And what is captured on this video is that a fair and accurate representation of what took place in that right?
that's correct.
Permission to publish state exhibit 4, portions 2906 to 3340. Objection, Your Honor, proper foundation. I'm not entering into evidence, it's just for permission to the jury for impeachment.
Approach. Right, so the court made its ruling, and you're both in agreement as to what's going to be played.
Yes, Your Honor.
All right, thank you.
The record starting at 29.
Dude, I swear to God, if I get fucking sick, I'm remember you, bro. I don't give a fuck. What part of your head? What the fuck you do? Yeah, you live, where you live, any of that shit, bro. If I get fucking sick because of these fucking crackheads that live on the street, because of you, yeah, it's what it is, bro. Come to my fucking court date, dude. Come to my fucking court date. I'm out of fucking order because why? Yo, I got pulled over after I got fucking kid. I was in need of emergency. I wasn't calling because I was doing something wrong. He stopped me because of an emergency. My car was disabled. My cheap out here driving around crazy. My daughter too. Hernandez, right? Alright, cool. It's a fucking Hernandez. You take care of me. Hey, look, there was no disrespect until you fucking put cuffs on me, bro. I'll do the fuck if you lock them and make me comfortable or not. I got the comfortable at this, dude. You're taking me somewhere I don't fucking know where I'm at. I don't know where I'm at, dude. Where the fuck am I? You're just taking me somewhere? Like, come on, bro. This is fucked up, dude. Fucked up, bro. You know, on the other side of the fucking town, and you're locking up because of suspicion? Your suspicion sucks, dude. Shit. I followed your fucking line. I did everything you asked. Yeah, I spent a couple times sideways. Why? It's sandals. Or took your sandals off. Dude, I want to be in platform shoes. And I'm fucking my steel-toe boots. I stand fucking straight. Steel-toe boots stand straight. But you know that though. And you didn't take advantage of that. You're gonna look cool for your peoples. Do your thing, bro. I hope you fucking look cool, bro. You're so fucking cool, dude. So fucking cool. Ruling Squid's fucking family, bro. Oh, really? I didn't fucking crash into nobody and hurt anybody. I didn't hurt nobody, bro. I didn't hurt nobody. Somebody fucking hit me. And that's what you do? Hey, I mean, karma is a motherfucker, and that's what you do, bro. So do what you gotta do, get in a intake, whatever, fucking see a judge on fucking weekend. Fucking piece of shit, bro. Taking me away from my fucking daughter, bro. Alright. There's a fucking packet Hernandez, so.
Starting at 3213 and starting back at 3340.
Bro, yo, I swear to God, if I get fucking sick in here, I'm gonna fucking come on you, bro.
And starting at 3340.
All right.
we just saw right there, was that a fair and accurate representation of how the defendant spoke to you on the way to the jail?
Yes.
And also, that morning, how did you find the marijuana on the defendant?
Go ahead.
The defendant handed it to me. He had it in his pocket, I believe.
No further questions. Thank you.
All right. Anything from you, Ms. Armbruster?
Hello again, Trooper.
Hello.
Is Mr. Smith the first person to use profanity towards you?
No.
Is he the first person in the back of your car to be emotional and say things out of anger?
No.
And when he stated that he was going to bring you to court, isn't it, strike that, is it insulting to you when a person that you arrest says, I'm going to take this to court?
No.
So you wouldn't count that as an insult, that he exercised his rights?
I would not.
And Ms. Santini asked you about the marijuana, but you would agree that you didn't test it?
I did not test the marijuana. No.
Could perfectly have been legal hemp,
The defendant told me it was marijuana.
but it could have belonged to anybody. And it could, my question is, it could have been hemp. You don't know because you didn't
Objection,
test it.
speculation.
Overruled.
You can answer.
I'm not sure. I didn't test the marijuana, but I was told it was marijuana.
But you didn't test it and you
I
don't
did not test it, no.
Did any of the, strike that, isn't it true that none of what Mr. Smith said in the back of the car really affected you?
To this point, no. Not that I'm aware of.
No skin off your back to have someone in the back seat of your car saying what they say?
Well, I mean, he did say he was going to bring me to court, so here I am today. But other than that,
But that's his right to have a trial, correct?
yes.
So
Other
again,
than that, no. Not
you
that
weren't really bothered by anything that he said?
no.
No further questions?
Any redirect?
None, Your Honor.
All right.
May I retrieve my laptop?
Yes, is Trooper Hernandez excused? All right, thank you, Trooper Hernandez. You're released. All right, State, you may call your next rebuttal witness. All right. Members of the jury, the state has now rested its case. We're going to take a brief recess in order to go over some preliminary matters before closing argument. So I'll let you retire to the jury room for that recess.
All right, for the jury.
Thank you. You may be seated. All right, anything we need to review before we review the jury instructions?
Your Honor, again, the state would just request that the defense be precluded from arguing inoperability as a defense in closing argument.
You didn't happen to print the court off a copy of Connolly v. State, did you?
I did not, Your Honor. Apologies.
I'll reserve ruling again. All right. For some reason, I have two copies of instructions.
I think we printed some out this morning. You may have gotten a second copy. They should be identical. Nothing's changed from yesterday, Your Honor.
Okay. All right. Ms. Armbruster, are you ready to review the jury instructions? All right. Any objection to 3.1? Any objection to 3.2? Any changes made to 28.1 since the initial?
No, Your Honor.
All right.
Your Honor, if I'm not going to be allowed to discuss actual physical control yesterday and today twice.
I don't think there's anything wrong with that.
Okay, so then no objection to 28.
Any objection to 3.7?
No.
Mr. Rapp, do you have an updated 3.9
Weighing the evidence?
weighing the evidence where the defendant testified?
That is included, it is the third paragraph from the top, where it states in italics, the defendant in this case has become a witness, so we could get rid of 3.9A and just stick with 3.9.
Do you want it?
And I will prepare a set of instructions, Your Honor, appropriate.
All right, so you'll prepare a new 3.9 where it's not in italics?
Yes, Your Honor. And I will get rid of 3.9A.
Any objection to 3.10?
No, Your Honor.
Any objection to 3.11?
No.
Any objection to 3.12?
No.
Any objection to the verdict form?
None.
Any objection to 3.13?
No.
All right, let me ask you both. Give me a second.
Here, do you want me to email you a copy? Your Honor.
Yes.
The state would just ask that if you do allow inoperability to be argued, that there be a special instruction for inoperability.
I'm sorry, could you repeat that?
Yes, Your Honor. If the court is going to allow the defense to make an argument as to inoperability in closing, the state would request that a special jury instruction be included as it relates to inoperability. That inoperability would not effectively mean a car that simply runs out of gas or can be rehabilitated through the definition. Ms. Santini's printing out a case for you, Judge.
But Judge, the issue that I think we agree on is that this car did not run out of gas. Its gas tank was punctured. So I would agree with Mr. Raps and stipulate this understanding that my car ran out of gas, but it did not run out of gas. And that's not any testimony that should be given for Mr. Smith today.
Who testified that it was punctured?
Right. There was testimony, I believe yesterday and today, that even for Mr. Love, that his tandem hit the gas can.
No,
the gas tank.
Your Honor, that was not stated.
And by Mr. Smith, and the trooper stated that the car was out of gas, but not, it was from the accident. We need to pull the court's mark for exact verbiage, but my recollection is that the car, it's not just like you didn't fill up and you ran out of gas. It was related to the accident that the vehicle was involved in, rendering it inoperable.
I don't recall any testimony from anyone that any damage to the Nissan caused a gas leak or a puncture to the gas tank.
Hernandez.
You asked him about the inoperability. You kept going back to inoperable, but you didn't ask anything about it not having any gas.
So when I asked him why, he had stated it didn't have gas. And Mr. Smith stated on direct that there was the issue with the gas tank.
I don't recall any testimony of Mr. Smith regarding the gas tank. All right, you have case law for me?
Print out yours.
No, I can't print it. I thought you were printing this for the judge.
Yeah, but not yours.
Okay. And that the judge can read it on his own.
All right. Neither of you asked for the instruction on edited recording during the playing of the redacted videos. Would either side want that to be included in the final jury instructions in past tense form?
Yes,
That's fine, Your Honor.
So, Mr. Rab, if you could prepare 2.2, and obviously it's in I guess present tense, and change it to past tense. And so instead of you are about to view, you viewed
Yes, Your Honor.
a audio video recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way. It must not impact the way you viewed or listened to and considered this evidence. Is that sufficient, Ms. Armpriester?
Yes, Your Honor.
Okay. And you want me to include 2.2 between 3.7 and 3.10 or somewhere else?
I think that's fine.
Okay.
No objection, Your Honor.
All right. Ms. Santini, did you print the Connolly case for me?
It's taking a while. I have 2 more cases coming.
It's not Conley, Your Honor. It's a separate case. It's Jones v. State. It also cites similar case law to Conley.
Do you want to provide a copy to defense?
I have both copies. I'm just waiting for the other cases to come so it makes sense. But if you want me to give it now, I can.
Go ahead.
Mark.
Your Honor, my internet has decided to take an untimely nap.
internet's not working, and I'm having trouble pulling up 2.2.
Okay. All right, just a moment.
Yeah, the jury instructions on your computer. So we're working just pull up the jury instructions. That's one. So, take this line out. So is this. Control. Take this entirely out. Like actual. Yes.
Is there another printer I can print to? Because this one is not responding.
I'm gonna email a copy of the 2.2 to the clerk.
Is it printing over there? Oh, I'm just trying to print the case law and it's not responding from that printer. Email it to you? Okay, thank you.
Jury instructions. My computer's not working.
I just emailed you 2.2. Could you print 3 copies of that? Thank you.
Thank you, Judge.
Yes. All right. Do you each have a copy of 2.2?
Yes.
Any objection to 2.2 as it's written? All right. And you both agree to the court reading it after 3.7? All right. Anything else about the jury instructions? Right. And now we're waiting on additional case law. Is that correct?
Yes, Your Honor, I'm gonna email it to,
Do you want to email email it to the clerk? Yes, you may. Yes. We're gonna go off the record. right, we're back on the record in State v. Jarrett Bird Smith, case number 20 CT 777. I think we last left off with the jury instructions. Did you get a 3.9?
Yes, Your Honor.
All right, and I have a copy of it. All right, any objection to 3.9 as amended? And do you want me to read 3.9 after 2.2 or before it? Okay, you agree, State?
That's fine, Your Honor.
All right, so we'll go 3.7, 2.2, 3.9.
Yes, Your Honor.
Okay, all right. And the court reserved ruling on the state's motion to disallow the defense from discussing inoperability at closing. Did I state that sufficiently?
Yes, Your Honor.
All right, and you've provided us with Jones v. State, 510 Southern 2nd, 1147 out of the 1st District. Hughes v. State, 943 Southern 2nd, 176 out of the 3rd District. And 36 Wash App 439 out of the Court of Appeals in Washington State. The State v. Smelter. Mr. Webb, do you have any additional argument that you'd like to provide, or shall I go to Ms. Armpriester?
Your Honor, you can go to Ms. Armpriester.
All right, Ms. Armpriester,
Your Honor, in looking at,
you may.
in looking at the state, right, I don't believe this applies. This was a commercial pilot operating in County. He was charged with operating an aircraft while intoxicated or in a reckless manner. And in this case, I just don't even if you look at the congressional intent and legislative intent, the facts are not anyway similar. This is a very lengthy case, approximately 20 pages, and see that the issues and the facts of the case involving Mr. Hughes include that of a commercial airline pilot who was working under a different duty. There was also a DRE in this matter. There was blood alcohol, not correct. Judges something that applies either way as opposed to inoperability. The defense is not trying to argue what the state is getting at. They are trying to argue the instruction in the law as it is written in the jury instruction.
All right, let's take each case one at a time. So let me just state, Ms. Armpriester, it appears that Hughes v. State was brought to the court's attention because of its analogy to DUIs, specifically found beginning on page 193 or page 15 of the copy, in which they discuss the defense of inoperability, which is based on a premise that a person ought not to be convicted of having a vehicle under his or her control while intoxicated, when in fact the vehicle was inoperable. The intoxicated person did not operate the vehicle prior to its becoming disabled, and the vehicle's mechanical problems were such that it could not, under reasonable circumstances, have been operated by the person accused. The difference that I see in our case here today is that we have testimony that Mr. Smith was operating the vehicle before it became inoperable, notably testimony from Mr. Love that Mr. Smith was the driver of the Nissan.
Which is why I'm confused as to why I'm not going for an operability. I'm just arguing that and as it relates to the car, the way that the trooper described it, and I believe it's a question for the jury, but the car did have to be towed away. And actual physical control on page 193 of this case, actual physical control of the vehicle means the defendant must be physically in or on the vehicle and have the capability to operate the vehicle regardless of whether he is actually operating it at the time. It becomes a question for the jury. Not
Right.
the time law enforcement came in contact with them.
I'm well aware of the definition of actual physical control of a vehicle, but what I'm looking at is the definition of the defense of inoperability. Because wouldn't that be your argument, that the vehicle was inoperable?
Yes, but that's not my main defense, and that's not.
I understand, but it's a defense to one of the elements.
I guess what I don't understand is if I can't go over the definition that the court's aware of, that I'm aware of with the jury, that's all I'm going to do. So I'm not sure what the state's attempting to preclude me from doing.
I think what the state is trying to preclude you from doing is arguing an inoperability defense.
And I don't know why they're.
It was brought up.
Based on the defense of inoperability, the definition, a person ought not to be convicted, and then it goes on, the intoxicated person did not operate the vehicle prior to its becoming disabled. That's not what we have here. And, keyword and, the vehicle's mechanical problems were such that it could not, under any reasonable circumstances, have been operated by the person accused. It was being operated before, according to the facts that we have before us.
Prior to, however, it was not operable after. When the state makes the main argument and the questions, I believe it was along the line of questioning of why didn't he call 911, why didn't he pull over? The car could not drive, could not move. After the incident, it was in fact inoperable.
It's not, here's Mr. Reb, the defense of inoperability, the definition, did not operate prior to and not capable. Let me rephrase that. Did not operate prior to the disabled vehicle becoming disabled, and the vehicle's mechanical problems were such that it could not, under any reasonable circumstances, have been operated by the person accused. We don't have the facts for number 2 in evidence, other than it was out of gas. And we know that we have facts and evidence that he was driving it before it was inoperable. So the defense of inoperability is not available to you, based on the facts that were presented in court.
And I never asked to have the inoperability defense. Mr. Rob assumed I was going to do it. I'm not going to argue inoperability. I'm simply going to go over actual physical control and its definition and apply it to the facts of this case. I never have said or gone on record that I'm using inoperability as a defense. But I would like to be able to state after the incident that the vehicle was inoperable and had to be towed away.
Don't you think that's going to, isn't that arguing the defense of inoperability?
Your Honor, the jury is not lawyers who are well aware of the definition of inoperability. The officer stated that when he arrived, the vehicle was inoperable and had to be towed away. And that goes to the severity of the accident.
I'll also note that the other case that the state provided to the court in Jones v. State, the court found that the defendant could not be convicted of driving under the influence when the defendant was found slumped over the wheel of a car stopped on a shoulder of public road. In light of evidence that the vehicle was inoperable, defendant did not operate the vehicle prior to its becoming disabled, and the vehicle's mechanical problems were such that it could not, under any reasonable circumstances, have been operated. Again, we don't have that in our case either, Ms. Armpriester.
Your Honor, I've never once asked to make the defense of interoperability, so I know.
That's what you've argued that you're going to discuss, though.
Well, I can find a synonym for inoperable. The car wasn't drivable, it had to be towed away. That was all testified to. If I'm not allowed to discuss in my closing argument what was testified to by the cop, then
Your Honor, if I may.
Go ahead.
Just for the record, it was brought to the court's attention in the second case that this armed prisoner did argue that the vehicle was effectively inoperable. Therefore it did not meet prong one or element number one. So my assumption again, Your Honor, is that this armed prisoner is going to use that in her argument in closing. And that is why the state requested that the court make a ruling on that matter.
Your Honor, this could have, the last 2 hours seemingly could have been avoided if the state and I had a conversation about it. What I argued in JOA, Your Honor, ruled on me denied. So certainly was not involved in the jury, and I made that argument outside the presence of the jury.
All right, thank you, Evelyn. State's motion is granted, and in light of that granting of the motion, Madam Clerk, here's the case law the state provided for that motion. Because jury instruction 28.1 states give, if applicable, the definition of actual physical control of vehicle, I don't believe that it's necessary for this case.
The actual physical control?
The definition of actual physical control, I don't believe is necessary to include in the jury instruction, given the court's ruling.
I would agree, Your Honor.
That was my request at the beginning of jury instructions, that I'm not going to be allowed to even discuss. Your Honor, you may want to be the one who gives, because if element number one, even if the jury asks a question about what that means, and if I know we're both going to go over the elements, because I've seen this Santini slide, and I've already stated I'm going to go over the elements. I think we should just leave it at Jared Smith drove a vehicle instead of instructing drove or was an actual physical control. And then we don't have to worry about the definition of actual physical control.
Mr. Rab? Would you agree to that? I'm sorry?
Yes, Your Honor.
Okay. All right. So, juror instruction 28.1 under element 1 will be we'll read Jarrett Berg Smith drove a vehicle. So, was actual physical control of should be removed. And then the definition of actual physical control will be removed. Is that what? Okay. All right. Both parties.
That's what I would get at.
All right. Very good. All right.
I will need to remember the point. I can do that with Post-it. I just need a precaution.
All right. Before I let you do that, Ms. Armpriester, Mr. Rabb, can you prepare an amended 28.1?
Doing so right now, Your Honor.
All right. And provide a copy to the court and Ms. Armpriester. All right. How much time does the state anticipate for closing?
45 minutes total for closing and rebuttal.
Same amount of time for you, Ms. Armpriester?
I would like an hour.
Okay.
Well, in that case, Your Honor, we would probably need more time as well.
I just don't want to, I just don't like to
All right.
under over I want to reserve an hour, but I don't use it often.
So what I would like to do then, since it's after 4, are there any other preliminary matters before going into closing argument?
Not that I am aware of, Your Honor.
Okay. It's after 4. We're talking about 2 hours for closing arguments. We're talking about another 20 to 30 minutes for instructions. So that would put us at 6:30. What I would like to do is recess for today and start closings at 9 o'clock tomorrow, or 8:30. Well, Mr. Smith, are you going back to the East Coast tonight? All right, so at 9 o'clock. Thoughts?
I have no problem pushing through, Judge. I don't have a problem for tomorrow. I just know we told the jury it's 2 days. But if Your Honor wants to recess, I'm fine with that. If you want to push through, I'm fine with that too.
Well, I'm more concerned with the jury's ability to pay attention to closing arguments.
Sure. We can wait till tomorrow.
Mr. Rabb, you agree?
Yes, Your Honor.
Okay. Any reason not to bring the jury in now so that we can recess?
No, Your Honor.
As long as they're told that we're gonna, I don't want them to think they're just, we're going home early, we'll start rushing in the morning.
Okay. I'll let them know that because of the time constraints on what we have left to do, that I think it's best that we start fresh in the morning. And so I will fall on my sword, so there won't be any blame to the parties.
Thank you, Judge.
Thank you, Judge.
Bring them in.
We're putting out the edited.
I just don't.
Yeah, I think he's got that. Just make sure that I don't.
Right. Can you? All right, Ms. Armpriester, have you had a chance to review 28.1?
I just handed it back.
All right, so no objection?
No objection.
All right, very good. Can we bring the jury? Thank you. You may be seated. All right, all members of the jury are present and accounted for. All right, we're back on the record for State of Florida v. Jarrett Berg Smith. Give me one moment here. Members of the jury, after discussing everything with the parties, and first, let me just apologize for what I'm about to say. And that is, I feel the need for us to go one more day because based on what we have left to do before we ask that you retire to deliberate, we're looking at another 2.5 hours at least before you start to deliberate. And that would put you deliberating at 6:30 or later this evening. And then I don't know, how much time you would need to deliberate. So with that in mind, and because it's been a long day, I think it's best that we start fresh in the morning. And we'll start with closing arguments tomorrow morning. So with that, we're going to recess, and I'm going to order you to return tomorrow and meet the bailiff at 8:45. The bailiff will give you instructions on where to meet in the morning. Will that be the same place they met this morning? So the same place you met this morning. And then that way we'll be able to start fresh in the morning. So again, I apologize for that. I know I told you it would be 2 days, but I think it's best that we go to 3 days instead of stay here all night. So with that, I'm going to release you, but before I do, I have a few reminders. So let me remind you that you're not allowed to communicate with anyone about this case. You cannot use electronic devices to research anything about this case. You cannot go to any location involved in this case. You may not have any contact with the defendant, witnesses, attorneys, or anyone else involved in this case. If you see one of the attorneys and he or she does not speak to you or even seem to pay attention to you, please understand that the attorney is not being discourteous, but is only avoiding the appearance of some improper contact with you. All of us are depending upon you to follow these rules so that there will be a fair and lawful resolution for this case. So with that, let me say thank you for your attention today, and we'll see you in the morning. It's a recess. All right, thank you. You may be seated. Any objection to the instructions that I gave the jury? All right, anything we need to review before we recess? All right, so I'll see you all at 8:45 in the morning?
In the courtroom.
In the courtroom. Okay, Mr. Smith? Okay. All right, court's in recess until 8:45 tomorrow. Okay.